Hey, what's up, everybody? How is everybody? Is everyone all right? Did everyone have a good night? Did everyone sleep tight? Good, that's good. I'm glad. I'm more than glad. I am over the strawberry moon. Yeah. So I just picked up a hitchhiker this morning. This old guy walking along the road. It was about 5 miles from town, and I said, "Hey, hop in, pops." Anyway, he got in my car, and I, in my best Portuguese, I said, "I'm going to this certain town. Where can I take you within it? Do you want to go to the supermarket? Do you need to go to this side of the town, this side of the town, whatever?" And he said to me, what did he say? He said, "Bleh, bleh." And I just didn't know what he was saying, right? So I asked him again. I said, "Sorry, what?" And he said, "Bleh, bleh, clinica."
Ms. Kaplan,
I'm not accusing the state attorney's office of doing anything. I'm merely...
Not accusing the state attorney's office of doing anything. Yeah, so anyway, he wanted to go to the clinic, which sounded like a good idea from his his speaking pattern. Go and get yourself a new throat, man. See if that doctor can give you a pill for that throat. Some fucking eucalyptus lozenge might help.
advising the court what transpired.
Hang on, whoa.
I'm not accusing the state attorney's office of doing anything. I'm merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well,
Yeah, because you're wasting their fucking time. The officer said, "I'm no longer willing to speak with you because, anyway."
we can bring in under Sheriff Google, however.
Sheriff Google. Who is Sheriff Google?
This does not invoke court to need to go through a Richardson inquiry. The witnesses that you're referring to, have they been disclosed to the state?
It's not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
If we can confirm the information.
These are not answers.
Shit, that was exactly my school uniform at some point. Navy blazer, light, baby blue shirt, and blood red tie. I mean, that was it. I'm having flashbacks.
If you are not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do with this. If you wish for me to hear from the under sheriff, I will.
Aloha, Melissa.
But as far as perfecting any subpoena and speaking to these people who are either not under subpoena or not listed witnesses, there's not very much I can do.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules...
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it, but please bring in the undersheriff. He can speak to these matters that you've raised.
Bring in Sheriff Google immediately.
Thank you, Your Honor. Judge, if I may. Whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself.
Oh, fucking Zellman just threw some shit back at the judge there. Wow. Without the court's assistance, we cannot accomplish them, and then sat down. Holy mackerel. See that again. He's showing balls.
Judge, if I may. Whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the
Amy, I think what's going on is that they want to bring in a witness, but they cannot serve her because she's made herself unavailable to receive a subpoena, to be served a subpoena. Which is interesting. I mean, if you just hide and they're never actually able to serve a subpoena, would you be breaking the law by refusing to testify? Because that seems like it might be pretty easy to achieve for anybody.
witness itself and the fact that it's occurring in the middle of trial. But that part of it, again, these are certain things I cannot assist with. And the Sheriff Google, please raise your right hand, sir. Do you swear or affirm the test?
I thought I misheard before, but it is actually Sheriff Google. Who's the undersheriff? Facebook?
Part of it, again, these are certain things I cannot assist with. And the Sheriff Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give to be the truth?
Yes, sir, I do.
If you can just stand in front of the court reporter instead.
Before he's revealed, do you think we get over there and it's just the big multicolored letter G that's going to sit in the witness chair?
Taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by...
To the best of your knowledge. Well, he's Google, so if anybody knows to the best of their knowledge, it's him. You know, he's going to give you 245 million results in 0.83 seconds.
Captain Georgia Dent, who has spoken with Deputy Franklin and
Deputy Franklin. Deputy Metrix.
informed Captain Dent that she had received a phone call from inmate Addison's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with general counsel, I spoke back to Captain Dent, and she relayed that information to the deputy.
Oh, Michelle, you've missed so much fun already, babe. This is Sheriff Google, and you'll pick it up. We'll pick it up.
Be frank.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
Any examination for under Sheriff Google by the defense or state?
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
Sheriff Google.
All right, she's not on leave, but is she hiding under her desk in her locked office?
There's no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
Concerning the other witness, who is not the guard, was the defense able to make contact with this individual?
Just a moment, Your Honor. Judge, the information that we provided to Your Honor was purely
I didn't hear that, Teresa, but I did used to have a friend that was had the last name Dick, D-I-C-K, and his girlfriend had the last name Cox, C-O-X. And I said to them, I said, you guys should get a pub, like an old country pub, and call it the Dick and Cox. How great would that be? Have you tried the sausage and mash at the Dick and Cox?
to put it on the record that we had followed that
It's on the
information.
record.
After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were being given.
Right, as to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as a part of your case?
There you are.
As to the guard, if you need to follow up with a subpoena for this individual, as they have chosen not to speak with you need to do so with all haste. The jurors at the time of selection were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
And I apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call.
I did not have a chance to prepare a list. What, the 3-day weekend wasn't enough for you? I did not have a chance to prepare a list. I mean, how do you have the nerve to even say that to Judge Everett? Do you think Judge Everett's up there for fun or what? That he likes having his time wasted every damn day that your client is putting on her case in chief? Is that what you think?
Kristen Adamson, Linda Bailey, Sarah Newhouse, and Marisol Descalzo.
For this afternoon.
This afternoon is up in the air, and that's going to require some.
We're going to see Motor Mouth Descalzo. Yes, Your Honor, I'm sitting next to Donna Adelson, who is my client, and seated in this chair next to me on my right. My left. Mackie. Mug. Mick.
Additional conversations with our client.
During the lunch break, that will be your opportunity to have any final conversations concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it'll be an hour and 30.
What, so if she testifies it's going to be today? Okay, we're in for a fucking ride here.
After that, we are going to have to go on the record concerning is she or is she not testifying.
Yes, sir.
Or at least they're going to have to put it on record. I mean, I wouldn't have thought it would be today, but we'll see.
Please bring in the jurors.
Your Honor, I know that 3 of the witnesses are here. Mr. Scalzo's flight does not arrive until a little after
10 o'clock, you said.
Yes, sir.
Oh, Ms. Koppelman, I neglected to give you an opportunity to speak. If you actually wanted to be heard, please do so now.
Let's ride. I like that. I'm going to write that down, Melissa. I like that. I like that a lot. Let's ride. I think I'm going to start saying that to my dog when we get in the car. Brian! Teresa's fallen off her couch. That's always a good way to start the day. Just stay down. Stay down, Teresa.
All rise, jury entering the courtroom.
Great comment that I wanted to read out about Donna's attire today. Who was it? Let me see. It was Hello Shiny. Here's what Hello Shiny has to tell us. I'll put it on the screen. Oh, we need to read more. This is a great comment. This is solid gold. Oh, that's the seal. We need that. Oh, let's just have a quick review of this guy. Did everyone see this witness yesterday? With the mouth that is 5 times too small for his head? I mean, what a horrible mouth. What happens when someone takes him out to dinner? I'll have a grape. Just one grape. That's all I can eat. One grape at a time. Oh, God. His pointy lips, it's just strange. Where's that comment? This is the one. Look at this comment. This is great. Hello Shiny says, oh fucking stop it. Is that 3 days in a row of the same cardigan and shirt in different colors? Is today candy stripe? Is she going for a college credits? It's over the top costume design. Costume designers worldwide are rolling their eyes. It's like costume AI. And I thought that was a great comment. The costume AI, like if you put in innocent old lady costume into AI, it would come up with that. But you know what it's also a little like? If you think back to the hit musical Grease with John Travolta and who played the lady? Sandy. You know, before Sandy gets cool and she's a good girl, this is how she arrives at school with her book bag, right? Even with the little hair curl at the end. I mean, it's Sandy from Grease. That's what Donna's going for, but as a 75-year-old, right? That's it. We've worked it out. It's probably her favorite movie of all time. Grease. Grease Lightning. Anyway, we got a lot to get through. Browser. Where is it? This one. Yes. Yeah, Soap's all right. She's
Morning, members of the
eagerly...
jury.
Morning, members of the jury.
Everyone can be seated. We are going to continue today with the defense's case in chief. Mr. Zellman, you may call your next witness.
Thank you, Your Honor. The defense will call Kristen Adamson.
Ooh, the lawyer. Wendy's post-divorce custody litigation lawyer that had to quit before she was in trouble. Olivia Newton-John, is that the actress? I would have never gotten that on a pub quiz. Fail.
Please raise your right hand. Good morning. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You may take your seat.
Thank you.
You may examine when you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adamson.
Okay, Ms. Addison, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law, and I have done so for 37 years.
How long have you been practicing?
37 years.
Okay. Are you board certified?
I have been in family law for 37 years. And how long have you been practicing? 40 years.
Certified.
Yes, I am board certified in marriage and family law by the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleagues in the Florida Bar Family Law section. I have to recertify every 5 years, so I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again, where I'll have to recertify.
My thing again? I'll be in my thing again? That's not very... You don't sound board certified when you have to say things. Well, I'll be in my thing. Just say a thingy. My thingy, my legal thingy.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the Executive Council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since 2020, and I was president in 2012.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
Yeah. In your work as a family law attorney, did you have occasion to represent Wendy Adelson?
I did represent Wendy Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not.
Oh, really?
That's not how I would characterize it.
How would you characterize it?
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because, unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that, and that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now, that are not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one. And
Little similar intonation with the speech there, right? That was Wendy. Does Aunt Lynn have an iPad? Abba has an iPad. What's his code? Does Aunt Linny have an iPad? That's what she does. Listen.
the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one. And another one was...
It wasn't quite in tune, but it was the same sort of thing. And these people, this woman should, separate herself from this case.
that I have right now is...
It's not good when you're a board-certified fellow of the whatever it was.
Person wants to move to Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here. So it's almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to be close to my parents. It's a very common thing for people to want to move to be near their parents, no matter how old they are.
Now, do you have parents who attend client meetings?
Not in my world, it's not.
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces. They do. I usually let them come to mediation because Sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood.
Armchair
Now,
quarterback.
you indicated that you typically have to go to court for relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation, that you have to have kind of special circumstances.
Look at the picture I just took of Soap. This is what she does all day while I'm doing this live stream. She sits there on the couch judging me. Doing your live stream, are you? Getting a lot of followers, are you? When are we going to the park? It's like the pressure she puts on to me is unbelievable.
And there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate. And so we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50.
Mary Claire is board certified with these weird witnesses. Aren't they all like paid actors that have been handed a script? You know, I was half expecting those friends of the Adelsons yesterday to come in and say, yes. No, I met Donna Adelson in 1978, and I actually went to school with her husband, Howard Adelson. Good old Howard. We were at high school together in New York City. I remember it well. It was just, what the hell was that display yesterday? You know what I did to myself? Just to double check that I wasn't going insane, I started watching that expert witness. I got a great sentence. I was going to write it down, but I didn't have time. I'll try and find it later.
50 shot at best. Sometimes a little bit more, sometimes less.
Did you have that conversation with Wendy Adelson while you were representing her?
I did.
Okay. And did you advise her of that same information?
I did.
Teresa says, what's this got to do with Donna? They're trying to show that the divorce was not contestuous. Is that a word? Tempestuous. It was definitely tempestuous and heavily contested, as we have from your client, the defendant, Donna's own pen, or typing, from her keyboard. We have all the evidence we need to show that the divorce and the subsequent litigation was very tempestuous, contestuous.
Basically, I told her that if this is something that was important to her, this was her one shot at it. If you get divorced and then try to relocate afterwards, you're probably not going to win unless something really substantial comes up and changes it. So if she wanted to try to be able to relocate, this was her shot at it at best.
So in other words, is it not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Now, the standard for a modification, what is that?
Hey, how you doing, Concert VIP 6221? Good to see you. Concert VIP 6221 says, new to the channel, it's my new favorite. Can't help but come back again and again. That's great, and welcome.
What's that?
Standard for a modification is a substantial change in circumstance. And at the time, that I had Wendy's case, there was also another component which no longer exists. But at the time that I had Wendy's case, you had to prove there was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. That detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
Is that why you advised Miss Wendy Adelson, if she wanted to try relocation, she should do it at the front end?
Yes. Proving detriment is hard to describe to clients because they don't understand how substantial that really has to be. It has to be very substantial. Children are failing in school, children are potentially being neglected or abused, or there's alcohol or drug or mental illness.
Okay. Have you ever been successful in convincing a judge to grant relocation?
I personally have only won one case in 37 years for relocation.
So, would you say it's difficult?
I think it's difficult.
Now, even though you've only gotten court approval for one with a client, have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases, sometimes through help of mental health professionals who will interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that that makes a recommendation. And if you have those things behind you, then it does help, because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an old...
They still have not made one single argument against the key evidence against Donna, which is incredible. Aren't you supposed to approach a defense case by, working your way up the bricks, brick by brick, like Jenga? Defense cases are supposed to be like Jenga, right? Slowly topple the tower one by one.
Older child who really wants to relocate and the other parent doesn't object. Or sometimes you have, like in my sister's case, which I actually shouldn't have, but I did represent my sister. She moved.
Ethical violation. You represented your sister and had a vested interest in the outcome of the case. You were not impartial.
To Atlanta, and then her husband was able to obtain a job in Atlanta and move up there to her former husband. So we negotiated all those things.
And I think you said you explained all of this to Wendy.
I did.
Was she aware that the chances of success were low?
Yes, I told her that this was her shot. I thought she had some good reasons. I would never have someone file a relocation if I didn't think they had a shot at it. So I think she did have a shot at it, for many reasons, but including the fact that her parents were...
Because of what she had convinced you of, right? Wendy would have convinced this lawyer to go in for relocation because of her own assertions about the treatment, we hear Wendy saying things like, I thought a divorce was best because I didn't want my boys to grow up thinking that's how you treat women. And, unbelievable stuff like that. Horrible stuff like that. Totally fabricated.
Down there that Professor Markel had a very flexible job. He had family in South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I felt like she had a really pretty good shot at it. But I did tell her it's not going to be easy.
Okay. Now, let's talk about family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the parties and lawyers and their paralegals help them fill out. We also have to provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other
The word is voluminous.
party, the other counsel.
And when completing the financial affidavits, specifically when you completed Mrs. Adelson,
Can we just verify that? I want to make sure that voluminous is not a fucking word, because I do not believe it is. You know, fucking 8-time champion, Scrabble champion. Voluminous. Voluminous is a moron word, and she means to say voluminous. Metrix, you did it again.
Miss Adelson's family law.
Let's hear her embarrass herself on the stand one more time. Hey, to be board certified and a fellow of the family law practice in North Florida, do you have to know how to spell or talk?
Financial.
Bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
How embarrassing.
And when completing the financial affidavits, specifically when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them and gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns, so you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on the financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits. And I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital, or they may not be, because what people don't always understand, it's an education process as you're educating.
Or some people lie their asses off and say, yeah, assets? What assets? It's my tennis racket. And my brother gave him that bicycle so that he can't have that gift anymore because it was from my family.
And your client as they're going through divorce, simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both.
Again, why, oh why, please someone tell me this. Why would anybody get married? With all of this crap? What's the upside? What's the upside? Other than, the bride being princess for a day, and that really seems all it is to me. I don't know why anybody would get married. These especially in the United States. What a bunch of stuff to take in. Assets, and if you obtained it but it's in your name, but it was in the divorce, it's 50-50. What's the upside? What's the benefit? Seriously. I don't get it. I don't get it at all.
And we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009, that $100,000 continues to grow, so you're entitled to the growth on it too as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court at least.
Now, I want to back up a little bit. What happened with Wendy Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendy Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that, and then at the end of our testimony, the judge asked to speak to counsel, which happens a lot, and she took counsel out. It was me and Professor Markel's lawyer, and she told us she understood why Ms. Adelson wanted to move, but she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendy go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So
I just had to look up the origin of the name Chauncey. And it's an Anglo-Norman and French origin meaning chance or fortune from the Old French word chance or chance, and was also a Norman introduced surname after the Norman conquest of 1066. The name also refers to a chancellor, a high-ranking official, and may stem from a French place name such as Chancey. So is it a soft ch? Is it Chauncey. Because I've been calling you Chauncey. Sorry about that, Chauncey. Chauncey. Very nice, very nice, very nice.
I talked to Wendy about that, and then Wendy's parents were there, and I actually spoke to Wendy and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendy ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
I wonder if I've got a picture of myself in the school uniform that looks exactly like his suit. Maybe. Probably not. Where would that be? I have no idea.
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss, because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013?
Yes.
Okay. And what was Wendy's reaction?
At that point in time, I think she was upset that she wasn't going to. I mean, nobody wants to not win their case. She was upset. She was always calm during all of.
Oh, what a boring witness.
She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation.
I could not work with this woman. I would not be represented by this woman. I would not give her 1 cent. I can't stand her speaking style, her look, or anything. And those things matter.
On the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for
Thug Life Ruth Markel in the audience? Oh, love it.
Wendy Adelson to offer Mr. Markel any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past,
Now,
and since that time as well.
Subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did, and at that mediation, we came very close to settling it, and we were there for quite a long period of time, but we did not settle it at the mediation.
Hello, my true crime lovelies. Oh, best intro ever. Best intro. Hey, did everyone see Paul's intro? Reporting live from my sofa. We got a special mention on on Paul's channel this morning. I gotta watch that later. Maybe we should all watch it together. I'm sure he wouldn't mind. Yeah, that's nice. It's nice when a channel that I really respect and that I've watched for much longer than I've had my own channel. It's it feels like an achievement. It feels like an achievement. And he's got a great audience. So it was very nice of him to give a special mention to our little channel over here. And who knows, maybe some new people will be joining our following. Or not. It was still nice. I feel like we need to up our game, though. Definitely need to up our game. If you want to help us up our game, support the channel. Support the channel on PayPal. Send us a super chat. Or buy us a coffee on buymeacoffee.com. Buy Paul a coffee. That'd be great. And thank you so much.
I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls and.
Nikki, Paul is from a channel called Reporting Live from My Sofa. Just another channel, a lot more polished than this, a lot more polished. But he's been doing it longer, so we'll get there. Just got to keep on climbing.
Because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
And before, we had a court trial set, I believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was if I remember correctly, it was the Charles Schwab account that we had listed on the financial app.
The Charles Schwab account. Why don't you just say $300,000? Yeah? Why don't you say that? The account. It was $300,000 and a priceless family heirloom that was smuggled out of Auschwitz.
Affidavit in the marital portion, and then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now, I know in our pretrial discussions, you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So,
boom! Thank you so much, Chelsea Myers, and I'm so glad that I've pronounced your name correctly. Thank you for the coffees on buymeacoffee.com/True Crime Metrix. Thank you so much, Chelsea.
it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is, and there's also
Pinto, how you doing, Pinto? GM, G minor to you.
an exception about what happens in mediation if the marital settlement agreement is asked to be set aside for some purpose, like fraud or overreaching or something like that.
Like fraud or theft or demanding money with menaces or
of it, and the mediation would potentially be able to pierce that veil of confidentiality.
But for our purposes, in order to talk about what specifically happened concerning that asset and mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd, he is not with us anymore, and Professor Markell is not with us anymore. So a lot of people in that mediation are gone.
Dead.
And Ms. Adelson has waived confidentiality.
You beat me to the punch, Ms. Edison. With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired into. The state may cross-examine as to all subjects as well. You may continue.
Thank you very much, Your Honor.
Oh, yes,
Ms.
they
Adamson,
can.
can you tell us that Charles Schwab account that you mentioned, how was that addressed at mediation?
So this became sort of a last-minute little dust-up during the mediation. So what we did was we called the Charles Schwab account representative. And
You know what this woman talks like? You know those like really flaky healer people that will say, yes, yes, I see, like a tarot reader. She's a tarot reader. I see bright things in your future.
and this is not uncommon in mediation, and I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined, in his opinion, what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple accounts apparently, and which ones were marital and non-marital. And then he went into the other room. We're not in the same room. We're in Ms. Adelson and I are in one room, and Professor Markell and his lawyer are in another room, and the mediator is going back and forth between the two.
She's doing that Wendy talk to the boys thing again, right? I can't stand it. Does Aunt Linny have an iPad? Abba has an iPad. What's his code?
Two rooms. So in our room, he listened to the what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement. And Professor Markell he had almost $500,000 worth of non-marital Charles Schwab accounts of his own.
Yeah. That got whittled down pretty quick, didn't it?
So he had non-marital money as well.
So based on what you've discussed, Mr. Markell was aware of the non-marital status of that portion of Wendy Adelson's portion of what she would get.
He was.
And as you said, shortly thereafter, that case settled.
Within a week, I think, ish.
Shortly after the divorce was final, did Wendy invite you to a get her groove back party?
I don't remember when the party.
Who just said they want to vomit? How do you feel now? Did Wendy Adelson invite you to a get her groove back party? Suddenly I want to put my fingers through my eyes into my brain and just pull my brain out through my empty eye sockets just so I can nurture it back to perfect health because I feel sick. Did Wendy Adelson invite you to a get her groove back party?
Party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was
Townhouse? No, it was a big old exclusive Northeast Tallahassee detached mini mansion.
called Wendy Gets Her Groove Back, and I had several friends I knew of Wendy's that
Jamie
were
G.
there as well, and it was just sort of a Wendy's in a good place, come celebrate my new life party, yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions. We had 2 mediations. One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
And costs of?
That includes costs and everything, I think.
Okay. Now,
I know that sounds like a lot, but it wasn't that much compared to a lot of litigated cases.
okay. Now, litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, we had. I don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, did the marital settlement agreement require that Mr. Markell pay Wendy and yourself certain sums?
So, according to the marital settlement agreement, Professor Markell kept the house. So he was supposed to pay Wendy for her part of the house. And all the other assets were divided equally, so that he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendy did, and it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendy did. So that was part of the agreement. He was supposed to pay me $10,000, he was supposed to pay her $120,000, all within 60 days of the agreement, which was.
Hey, Sally, thanks so much for the generous support on PayPal. That was quick. I only just put this thing up. Well done, Sally. Thank you so much, Sally. You rock. Fantastic. If anyone wants to support the channel, please go to PayPal me /True Crime Metrix.
It was July, sometime 2013.
July 31st.
I think that's right.
Did Mr. Markell pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendy, the money. He gave her $50,000 of the $120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markell was going to pay.
Did he pay?
He did not.
What did Wendy ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay, so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier if people will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and he owed me money, and I asked for a court hearing on all of that.
I don't know, Sally, how we are still on this first witness when there is nothing here. There's nothing here. I think that they're just trying to make sure that the jury has a lot to talk about. Or that the jury might or that the jury might be confused, like, did the defense make sense? Because there was so much and it went on for so long that I really wasn't listening. Because, if that happens, this could well be the tactic, seriously. If these jurors are so bored that they are turning off their mind, that could be quite clever. Because they might feel guilty and then think that they would have found a point. Oh, I really should have been listening. I'm not going to be able to convict because I don't know what was going on, because I switched off my brain, because I don't have any attention span. It's not their fault. Set her free.
Sounds like it was pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Did that prompt Mr. Markell to pay?
No, it did not.
What happened?
So then Mr. Markell hired a new lawyer.
I cannot listen to this woman anymore.
New lawyer.
What is with this sort of sleepy, dreamy, sighing your words out kind of prose of hers? So then Mr. Markell hired a defense counsel and filed a motion to withdraw. What is that? This breathy speak. I cannot stand it. I hate it.
Filed a responsive pleading to that my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this first response.
He filed multiple motions, just like our darling Sally is filing multiple support super sticker. Thank you so much for the super sticker as well, Sally.
Responses and motions. His first one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden...
She shouldn't have to pay because he had hidden assets.
The Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense because if he had power of attorney, he would know what the money was. So it didn't make sense to me. But anyway, that she had hidden that money and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached and he shouldn't have to pay her the money.
So he filed a response But did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendy at the time, is that is not a proper defense for not paying the money. Professor Markel, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous, and it was very personal about what was going on, and Wendy and how I don't think.
Whoa. She just said voluminous, right? So why did she say that non-false word earlier when she said voluminous? She obviously knows the word. I guess she just misspoke. That's kind of embarrassing when you're on the stand as a board-certified fellow lawyer of the whatever it is.
At this point, he might have alleged that she had committed fraud, but an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically, if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
you filed a motion to strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it wasn't the correct way to go about doing it.
What was the Wendy Adelson party called? Did Miss Adelson invite you to a Get Her Groove Back party? What do you think was playing on the jukebox at that shindig? Celebrate Good Times Come On? Or something equally as nauseating? How about I Believe in Miracles by Hot Chocolate? I'm guessing it was all stuff like that from the Now That's What I Call Music, or you probably don't have that record in the States. It used to be a compilation record that came out every year of all of the biggest shit hits. All of the shittest pop music that you could imagine was on that compilation album. It was a thing called Now That's What I Call Music 45, 46, and so on. That is her only CD.
What he wanted to do, and so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
In the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendy's part?
I think he filed at least one or two more pleadings that did that.
And before we get to the final one, that you advised Miss Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily involved with mediations and lawyers and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards and the marital settlement. Here's the question.
when Wendy is arrested soon after trial, because that's happening. Let's not speculate anymore. Is it 2 weeks? I don't know. Soon after, I'm willing to say that. Will she invoke her right to a speedy trial? Will she have a successful Arthur hearing? You know, we keep commenting on that. For anyone that doesn't know, an Arthur hearing in the state of Florida is when you petition the court to grant bond on a non-bondable offense, such as murder. And we're pretty familiar with the standard. And we see why Charlie and Donna did not have successful Arthur hearings. But by that standard, does Wendy meet the criteria for the court to refuse it? She certainly would have a better shot. So when she's arrested, there'll be a bit of fucking around, but at some point there'll be an Arthur hearing. And the court will have to listen to the reasons that the defense team, and don't forget, Wendy Adelson's going to have a defense team that make these chump change munchkins look like, chump change munchkins. I'd say she'd have a shot. Probably not. George is going to come in tough with the Arthur hearing. She's going to not want Wendy to get bond. So in that case, would Wendy benefit from a speedy trial? She's certainly had enough time to prepare, as of the state. I mean, in reality, it's possible, see the Wendy Adelson trial before Christmas or in January. Wouldn't that be something? There's this perception that it's, even if she's arrested tomorrow, that it's going to be 2 years from now because of the flow that we've been in. But she will have a right to a speedy trial if that is something that she wants and her defense team wants. Right? Imagine that. 2 Adelsons down in 2025. Wouldn't that be something?
Settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response, and I told Wendy that it wasn't, and not to worry about it.
Now, there was a hearing in February of 2014. I think the records indicate that that Mr. Markell and his attorney were attempting to...
That's correct, James. At least that was the accusation. This is the family law representative of Wendy Adelson in the post-divorce custody litigation, relocation litigation, that withdrew from the case for fear of having her name tarnished and no longer being in good standing with the Florida board, right? I mean, Dan accused her and motioned against her of having unclean hands, which, nothing takes away your board certification quicker than that, believe me.
Pose, Ms. Adelson?
So what happened was I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order.
This is interesting, kosher style. Was I just on mute a minute ago, or no? Okay, I don't know. I hope not. Amy, did you hear what I was saying about Wendy's arrest? Or was I on mute? I wouldn't mind knowing what people think about that. Kosher Style says, I tuned out yesterday. The First Lady lying was too much for me, and Wendy can't use Viber as an excuse, as it only was complicit for calling with Windows phones, and they all used Apple phones. See, I didn't know that because I've not heard of Viber before. I don't think that's a thing here. But something I remember from yesterday is that WhatsApp didn't include the feature to voice call until, I forget what it was. I think it was sometime in 2015, which is an interesting fact that I didn't know. Up until that point, it was only text messages, that you could do on WhatsApp, which I can't say with certainty off the top of my head, but I feel like we've heard Wendy talking about using WhatsApp to voice call people for periods that were prior to that feature being added to the application utility, right? So interesting, and technical details. Windows phones, so Viber was only complicit. I'm not sure that's the right word, but for calling Windows phones. I mean, Donna had an Apple iPhone, right? I guess people can have two phones. I don't know, but that lady on the stand was like, well, it must have been Viber. Interesting.
Order so that he would not take her deposition. We went to court on that issue in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing, the judge read all of the pleadings, and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye, and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markel file an additional pleading concerning complaints that he had about right of first refusal?
I actually really like Shake Your Groove thing. Jojo, what is that? Peaches and Herb? What a mover. What a mover.
Parenting time and things of that nature.
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now about the parenting, and it was that Wendy wasn't allowing him to FaceTime with his children as much as he wanted to. That they weren't allowed to go to be present at the same birthday.
Nikki says, it's crazy you have to sit in jail before being found guilty. Well, they need probable cause, if that's the right term. They need to have, evidence to say that, yeah, we really think it was you. And don't forget, some defendants that are awaiting trial are dangerous, very dangerous, and serial rapists or people could interfere with witnesses, be that through intimidation, payment. I mean, it's I don't really see an alternative. I mean, they do have a right to a speedy trial. I mean, what else can we do? If someone's arrested, you know, like, I don't know, a school shooter or a drug lord or, I don't know, you know, some dangerous criminal, what do you think we should do? Just arrest them and say, okay, I'll tell you what, come back in a couple of years and we'll do this trial that's going to take away all your freedom forever or give you the death penalty. So make sure you're here at 10:30 for that. You know, do it on trust. I don't see that the system would be quite as robust if we were to do something like that.
Birthday parties, that if there was a birthday party that he was at, she wouldn't come. I mean, things like that, and that that she wasn't. I think there was a right of first refusal in it, and that she was letting her mom watch the kids, and he didn't like her mom watching the kids, and I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time. He also, I think it was that pleading where he went on a little bit more about Wendy and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
As he's filing these things, are you still trying to set a hearing, or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Okay. Now, the one motion concerning his my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals. But it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to put up roadblocks to parentings. And I've had cases that were pretty serious in the past where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they become completely aligned with one parent inappropriately, and not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks.
Parental alienation. Wait until we get to Trevor Summers. We've got to be doing Trevor Summers soon. I think we should do a quick fire. Let's try and do the whole thing in like 4 episodes. Quick fire cases. That'll be our new thing. That'll be our brand new thing.
They do use those terms. I've seen it.
Okay. The statements that were included in the March 26, 2014 pleading filed by Mr. Markell that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No. It's not possible. And I told Wendy that.
Okay. Now, as Professor Markell continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may have been 3. and it was the last one that he filed. I believe it was in May, I believe, where he said that where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened.
That's not being personal at all, okay? Being personal is if he said, your hair is horrible and you're trying too hard, you know, trying too hard to cover up your unfortunate face, and your kind of whisper, breathy speaking style is annoying as fuck and makes me feel like I'm being hypnotized. That would be personal. So, you know, saying that you committed fraud and that you've got unclean hands in your profession, it's not personal.
At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able, prior to withdrawing, to schedule the hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
Okay. And around this time, were you aware that Mr. Markel had to change counsel again as well?
I did not know that.
Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I've really only dealt with Wendy.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendy Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to.
What are we, 2 hours in already? Almost? Unbelievable that this witness is up here so long. I can't believe it.
But even then, it was very brief. They were very nice, lovely people. I didn't, even after even afterwards, they were fine. I had no issues with them, but I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
Okay. And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Okay, just a moment, Your Honor.
Nothing further this time?
Cross-examination.
Thank God. Georgia, let's go.
Morning.
Good morning.
So you said you weren't aware of Donna Adelson's involvement.
Oh,
She was
Sarah.
not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings, how about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendy, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendy on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, you know, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this, that's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendy sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendy.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that time.
I'm always hopeful, you know, but
Right.
And I thought she had a good shot, or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes.
Okay, even given your best guidance?
Yes.
Okay. That's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right, and at that relocation hearing were Donna and Harvey Adelson possible witnesses?
You know, I've been trying to think about that. I think that that's probably why I had them sit outside, is because
Right.
they could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So
and-
that's right. Yeah.
Okay, so that's why they were in the hallway.
That's why
most
they were in the
likely.
hallway. Yeah.
Okay, not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. Came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
Well, I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendy was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendy Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No, okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendy, and then briefly, as far as I remember, because I mean it was 13 years ago, I think I talked to all of them and kind of told them what happened and what was going on. And, you know, I didn't agree with the judge, but this is the judge, and they get to make the decisions. And I think that Wendy went and talked to her parents without me, and then came back and said, okay, we're good. We can go into court and we can stipulate.
Okay.
Which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face?
No.
Okay. You talked about Dan Markell not paying what he was supposed to pay according to the settlement agreement. in Dan Markell's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact of that he was accusing Wendy of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markell held in contempt of court?
I did. It was part of my motion was to have him held in contempt of court and enforced it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue, and that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying, and then.
Could I ask you a different question?
Okay.
I'm sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step. And it would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequence is we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and we would, and I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money, and then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien. Worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license, possibly? If he's held in contempt of court? Or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Did you inform Wendy Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did. Because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendy Adelson should be held in contempt?
I don't know if contempt, I can't remember if he actually said she should be held in contempt legally the way that I was using it. I think his pleadings were much more, Wendy should be disbarred.
Okay.
I mean, that's what he specifically said.
Right.
That she was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun, but for the most part, we kind of settled it. We settled it after mediation, and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine, and then all of a sudden he decided not to pay the rest, and I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendy or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is when he did that.
Was that personal attacks on both Wendy Adelson and you?
Correct.
And he was alleging that Wendy Adelson committed fraud, right?
Yes.
He's alleging you committed fraud.
I did.
It got so bad that you had to get off the case so that you could be a witness on Wendy Adelson's behalf, right?
Correct. That's happened before, though. I mean, I've had that happen before.
And he alleged Wendy should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal, because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markell and Wendy Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on Wendy Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not. We've had a few people get murdered, and I've had a few suicides,
Okay.
but it's rare, and I remember all of them.
Right, but not contentious.
Sometimes I don't know with the suicides. I don't know.
That's all.
Thank you.
Redirect examination.
That's a good strap line for your publicity. Yeah, we had a few suicides. Yeah, when I sent them the bill, some of my clients took their own life.
Briefly, Your Honor. And first witness.
You may.
Ms. Adamson, I'm going to approach and show you some, I'm sorry. Ms. Adamson. States demonstrative A, I think it's Court Exhibit 1, page 441 of the demonstrative. And then I'm holding 454, if you can hold that,
Sure.
please.
Okay.
Is that the March 26, 2014 pleading that Mr. Markell filed?
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's, time with the children? Does that reflect that Mr. Markell was asking that my client's unsupervised time with the children not interfere with his right of first refusal?
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Ms. Adamson,
Did you testify that the divorce was not contentious, but some of his pleadings post-divorce were contentious.
I think that's accurate.
Okay. And that his pleadings were personal. He essentially he attacked both Wendy Adelson and yourself.
Correct.
Okay. Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks.
Split pea soup blouse is a very nice way to describe the color of baby diarrhea. You know, what did your personal shopper tell you? Do you have anything in a sort of, business style baby diarrhea shade of green? Yeah, I'd like to see everything you have in baby diarrhea.
The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness. Not because I cared what he said about me.
Had Mr. Markell not...
Well, you clearly don't care about committing perjury like you are doing right now.
included in his pleadings these attacks.
But I guess it's not really lying if you know that there's no way to prove that against you, right? No ethics, no ethics. Fucking board certified. The board should take away her certification and ban her. Disbar her. Make her leave the state.
Would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling. To you.
As far as I know.
You don't know what she said privately, do you?
I do not.
Concerning Wendy Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you?
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts, and then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendy Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendy, I don't remember that Wendy had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of ChatGPT now, a lot, telling me what I should be filing.
I don't think you're the only one there, ma'am. Had you not withdrawn to be a witness, the motion...
What's that supposed to mean? That your job has been made superfluous and all your experience and law has been taken over by a machine? They're coming. The machines are coming.
would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay,
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further?
Will this witness be recalled?
Just a moment. We'll retain her, but she's free to go about her business.
Thank you.
You may step down. Please call your next witness.
Your Honor, the next witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor
Quite lengthy.
take a brief break. The jurors need one.
Do any of you need to take a break or use the restroom, please?
Yeah, they're going to take a break.
A very equivocal wave, but I'll take it. The bailiff will take you to the jury room. Resume at 10:05.
Who was this lengthy witness?
Good morning.
I guess we can skip ahead. Look at him. Big old judge.
You can be seated. Does the witness have anything that she needs to set up?
No, she's testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to. And we'll try to start again at 10:05.
Thank you, Your Honor.
Could be quite a lengthy witness. Like that wasn't and completely pointless.
And look through the sidebars for Thursday and Friday to determine when the topic of Linda Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom, whether or not there were any other matters that were discussed along with that. I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Keppelman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
And I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey, we'll review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why
Okay, so now Georgia Kappelman is dressed as a 19th century African safari. What is the word? You know, does she work for Leopold II?
we try to keep these witnesses isolated from each other.
You can let the jurors know. I'm going to go to the court reporter's office to check the sidebar.
Hello, Shiny says, hey Metrix, so yesterday's Lewis video, the whole one gun thing, interesting. Lewis said he thinks it was one gun, but minutes later he says he can't remember which gun Sigfredo used to shoot the hole in the car. Okay, yeah, there is some changing of the story with the gun. Of course, we're going to be going over Lewis's testimony again, comparing it with previous years, comparing it with the Profer, all to play for after the trial. And I'll make a note of that.
We'll finish this matter and resume the testimony.
I listened to Tag video today. Or that video today. Long drive. It was one of your best, going off on Bob. She went off on me. I defended myself. You all saw her. She had a gun. I'm sorry if I'm a little impatient, but you know that these people keep coming with ill thought out, you know, ill thought out ideas and opinions, and they need to be stopped, you know. Maybe eventually everyone will think twice. If people just took the time, you know, to think. What I don't like about it, and the reason I might react a little hostilely, is because I recognize that the eagerness to go to a conclusion such as, what was it Barb was saying? That she didn't believe that Sigfredo and Lewis threw the murder weapon in the water because guns were valuable. You know, the thing I don't like about that statement is not just that it's wrong, incorrect, and ill thought out, is that I recognize that there's an eagerness. It's like a treasure hunt, right? It's like a treasure hunt, and people are so eager to find that treasure and unearth it and bring it back and receive their acclaim for doing so, that they get lazy. They get lazy, they jump to conclusions, they put some bullshit together in their minds, and then they bring it to me. Well, you know, I've had enough of being patient with that. I just, new manifesto. We're not running a school here, okay? We expect everybody to be as knowledgeable as us. Or close. Do your best, do your best. You know, if you do your best, then that's great. But the laziness, the eagerness to find that treasure, that annoys me. And not just about this case, but in society as a whole. You know, it's like the drive-through window of a murder investigation, right?
Please make your arguments.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 60.
That's interesting, A. Johnson. 5542. That lady came to take a swing at a dead man who caused her a lot of professional grief, which she was outmatched against while he was living. It was barely masked. Yeah, very poor taste. Very poor taste.
We specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses. We were not asked.
We haven't shown the cars today, have we? Where are they? Where's our car diagram? We got Tom Petty there. He's always good. Where's our car? There. I heard that there may have been an attempt to the killers hire a car that looked like Jeff car. They're still all going on about it, aren't they? I bet they're talking about it on other channels. I bet they're talking about it on. Did you know that a Toyota Prius looks exactly like a 2004 Nissan Sentra? Did you know that they actually hired a silver Nissan? Oh, blah, 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 blah. Do me a favor. Do me a favor. It's not true, and we have proof. We've done it a number of times. We've Amy, I didn't bring it up. It's blame Hello Shiny. I'll bring it up any chance I can until everybody knows the truth. That's why we're here. Okay.
Asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert.
I love this. This is exactly it. Hello Shiny 8475. The want for approval for amateur detectives is annoying, like kids expecting their shit art to be put on the fridge. That's exactly what it is.
Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now.
Judge.
What do people say about the cars when it comes up on other channels? Are people in the comments going, they don't look the same? Metrix told us the truth. I should watch other channels, but I don't really like them. You know, that's why I made my own.
This witness be permitted to testify, Mr. Zellman?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no.
If Judge Everett, I would pay $1,000 to hear Judge Everett say "sit down" shuffles. That's fantastic. I hope I dream about that tonight.
Expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Kosher Style says, yes, they're talking all about it on other channels as gospel. Oh my God. I'm going to have to find out about that. I might have to do a special car episode. 10 hours long. You hear that, Amy? Special car episode, 10 hours long, where we go through the opinions of others. Oh. I mean, yeah, right. Let me write something down so we know we have to come back to it. Special car episode. 10 hours.
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's this conversation to authorize Miss Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual, or even brought up this topic to make sure we did not end up in this point and place?
Judge,
Wow.
we thought we adequately addressed it last week during the sidebar.
Ms. Cappleman, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy, but
It's
did
already
admonish the
over.
defense to not let it happen again, and now it's happened again. So, you know, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So,
As to
Whoa.
the state getting a fair trial, Ms. Cappleman, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may.
Last word.
Whoa.
Earhart. Exclusion of the witness. Court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This
Absent.
is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that Profer can be taken on this matter. And after that, I will step down, briefly review what I need, and make a ruling. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated. You may inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
And Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc. in the Adelson-Markell divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple weeks ago just to confirm
Sorry to interrupt this, because this is quite exciting at the moment. But hello, Shiny. Look, I'm gonna have to borrow this line. I hope you don't mind. But that's perfect. Fact: a Nissan looks like a car. Second fact: a Prius looks like a vacuum cleaner.
What I supposed were facts, and I have known Kristen for 40 years. We went to law school together, and I know how she practices. I practice against her often, so I had some ideas about the lack of strength of Mr. Markel's motions, and she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donna Adelson and Wendy Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendy Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendy as well.
And in preparing for trial, in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And you sat this morning through Miss Adamson's testimony.
I did.
Why? Because it was so interesting and gripping. I mean, what? She could have been outside in the sunshine, going to the Metro Deli, eating pickles. You know? Hey, talking of bad hair, we got a couple of candidates in the gallery right now. I won't say who.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Miss Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Captain, done an examination for the purpose of the proffer.
All right, she's not going to be excluded, but that would have been cool, man. Second time. So yesterday, the defense broke the rule of sequestration by allowing one of their witnesses to come and see the testimony of someone testifying prior to them. They were admonished. The judge said, no, don't let that happen again. And he was pretty firm about it yesterday at closing. And, there was a big, long sidebar that we had to skip through because it was so long, where they were talking about the exception to the rule, when it's appropriate. So, loosely speaking, it's appropriate when a certain witness, expert witness that's testifying in the same field of knowledge as the as their counterpart witness, if you like. I think that there's an exception where that can happen, limited exception where that can happen. And today, the defense have allowed another witness to break the rule of sequestration and watch a witness who testified prior to their own testimony. Georgia Kappelman is calling for the most extreme action, which would be exclusion of that witness. You're not allowed to testify anymore, which would have been fucking amazing, but I don't think it's going to happen.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms.
Wow!
Adamson?
Even when she puts the glasses on her head, look at that. It's just landed. It's like a painting, it's so perfect.
This is the Profer.
Oh,
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your
No, I don't.
preparations?
I think so.
Okay. No, Your Honor.
Please step down, Miss Bailey.
how is it that every woman on planet Earth is born with this special talent, gift to get out of the shower and kind of instantly make a turban out of a towel and wear it on their head? I'd like to see a picture of Georgia Kalperman with a towel turban. You know that happens probably every day, right? I bet even then, when the hair's all covered up, she looks great. But yeah, no man can do that towel turban thing at all. But women don't even need to be trained. How is that? Why is that?
Return in a few minutes.
Yeah, maybe that's what Donna's been so confident about. Kosher style. Kosher says, I see it now. Holy shit, I see it now. The defense is trying to get a mistrial. Well, I think that's always kind of a hope, right? That would certainly satisfy their agenda. They know evidence is damning for conviction. Then they'll ask for bail awaiting new trial with Diddy level monitoring. Yeah. I don't think she'd be granted bail. Why would she be granted bail? Carol Johansson 2807 says, I was way back, but I had to catch up because Josh Selman and that lying attorney for Wendy makes me want to break something again. By the way, Soap is not judging you, she's admiring you. Why don't we all look at Soap? Let's all look at Soap and just calm down. Or we could talk about cars. I know, sorry, Amy. I was about to call you Wendy. I know Wendy loves talking about cars. Or Amy. Where's our picture of Soap? So this is Soap this morning on her mansion couch. It's a little dark. Judging me. You hear that, Soap? Yeah, that was pretty exciting, Amy. I guess I'm a little behind on these comments. They tried yesterday to get a mistrial before the judge came in. They tried to get a judgment of acquittal, which is a lot better than a mistrial for their cause. That would be free and clear, you know? That was basically to say that the state hasn't met their burden. It's no point putting the jury through a needless defense because it's obviously not guilty. Judgment of acquittal. Well, to get the charges dropped, the defense did first thing in the morning. Total joke. Everett said no more. No, move on. Yeah. So, did they intentionally violate the order? I missed the last 10 minutes. It was good. It was good, Brian. The Judge Everett was absolutely, totally out of patience. But I just gave a description of what happened. Hopefully you caught that. Wait, I had to go back. I didn't catch what happened just now. Just Selman standing up bitching again. Oh, it was good. If you look at Judge Everett's considerations that he gave and his tone in asking Kappelman what remedy, that's the word I'm looking for, what remedy would be appropriate, Georgia Kappelman went straight to exclusion, which is the most extreme remedy. That would have been so cool if that had happened. Yes, request for dismissal is standard before defense presents. However, they had witness in courtroom. Now today's shenanigans, they're trying to throw the game. I watch other channels, so now I'm going to make a point of saying no. Metrix A says no. When it comes up, we should all do. Yeah, please do. Please do. And I will be making a case about this that's easy to find. I'm just going to have to sit through a 3-hour video of my least favorite creator. I'm going to have to suffer through that. Maybe I could get an AI program to change the voice into something that I can tolerate. Surely that must exist. If I have to go and do a counter argument against the least favorite other creator, can I get an AI program that could change their voice into something that I could at least tolerate? That would make it easier for me. Jeez. And I never wanted this war. I never wanted this war at all. I was always cordial, polite, and, it is what it is. Don't say anything about the cars on Carl's channel. Just don't argue on Carl's channel or cuss. I love Carl, but he's real strict on stuff. Yeah. Oh, Carl. I respect what he does. But is he pushing the car theory? Surprises me. Happened to, because the lawyer text talk gets boring. Wow. Has another witness been in the gallery? Yeah, that's what it was. Oh my God, Judge Everett is having to stand up to address this idiot and explain that he can't have testimony stricken, that he called the witness and asked the questions of what is wrong with him. How can they even argue the divorce wasn't contentious? It's unbelievable, right? Unbelievable. When your mum is referring to your husband as an asshole fucker. And that was the least of it. To get what he's always gotten. His way. Get to him emotionally. He's going to want you to stop this. List out all of his assets that he's collected during the marriage. I mean, it's a contender for the most contentious divorce ever. Fucking Johnny and Amber are like, you know, a mutually beneficial, positive relationship compared to this. Harmonious. Dan and Wendy makes Johnny and Amber look like they were, you know, in perfect harmony. The defense is really pathetic. Rash Baum was pathetic. I am certain that Luis Rivera has the best legal representation. Yeah, the Collins, David Collins, and I forget the other one's name. Father and son team. They got him that sweet deal, and we saw Chuck Collins, David Collins and Chuck Collins. That's it. Chuck we saw with Lewis in the Profer, and he was great. Really nice, really good. Make a satirical video explaining a golf cart next to Jeff's car. Oh, that's brilliant. That's brilliant. And then we'll go the other way and do a Bugatti Veyron. If the killers had driven a Bugatti Veyron to the scene... Satirical video. Golf cart is identical to a Nissan Sentra. Thank you, Kosher Style. That's very, very good. Can Georgia show the jury the 4-inch thick binder of court filings in the divorce case? Yeah. Or any of Donna's emails? What did the defense do? Oh man, I am way behind. I'm just going to have to quickly go through these. They had Wendy's former divorce attorney testify as an expert. Yeah. Somebody is sitting there on purpose to be seen on camera, surprised they're not holding a sign up saying, "I'm the Mark L. Case OG." Make a thumbnail for a rental car video. It's a car rental place, and there's 3 models to choose from: Toyota, Kia, and Jeff's car. Make a thumbnail for a rental car video. Yeah, I think I get what you're saying. Does anyone think the jury is buying this? No, not at all.
Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated.
Yeah. But Judge, that test that you're talking about is referring to a one-off isolated incident. This is the second time in 2 days that this has happened. So what's the sanction to the defense? There needs to be a remedy.
That in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial, as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to...
Oh, you need to sit the fuck down, son. Do not say anything else, Judge Zellman. You've just got to keep your witness and not have her excluded for your fuck up. Your multiple fuck up. Sit the hell down, okay? Don't push Judge Everett. He's already right on the edge. He's about to leap off the bench. You know, it's like, God. Unbelievable. I don't think I've ever seen that happen before. Not twice.
Specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand. If there are any additional matters that need to be clarified, this needs to occur so we don't have any more issues with witnesses or other problems. Everyone can be...
I think I should have got some sweets. I think I might get sweets for tomorrow.
Seated. Ms. Bailey, please rise to be sworn. Ms. Bailey, please rise to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. You may examine as you're ready.
Thank you, Your Honor. Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school.
Please tell us about your educational background. Well, my post-high school educational background is thus and so. Yeah, okay. Well, he didn't mean start at kindergarten. When I was 3, I went to the Tallahassee Play School, where I received an award in sandboxing.
School in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adelson, so
Okay.
we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When during law school and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law, and what that requires is an application that's about 3/4 of an inch thick that details all of your child practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, etc. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to
She went to school with Kristen, the previous witness, Amy.
opposing counsels and judges in front of whom you practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, and before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, Bailey.
Thank you. How many board-certified family law attorneys are there in the state of Florida?
I believe there are about 274, according to the Florida Bar.
Okay. And do you know what percentage of lawyers in Florida are board-certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, that'd be less than 3. There's less than 3 board-certified family lawyers in Florida? That seems... Okay.
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to
and they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
And judges also get that same peer.
I just want to go on record to say that I have absolutely nothing against Carl Steinbeck. Respect his knowledge, and opinion and passion and everything. I mean, certain creators, I'd be very happy to have learned that they'd been hit by a bus, but Carl's not one of them.
Review.
They do.
Do you have any other certifications?
I'm a board Supreme Court certified mediator, and that was probably the mid-aughts, 2006, 8. I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course you do co-mediations with other mediators.
After the course, you go to Disney.
And then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education that might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review, and the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests, like have you provided presentations, have you taught, have you done certain community service or pro bono work, that sort of thing.
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines, but at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
The state wished to voir dire the witness as to their training or experience.
No, Your Honor.
Any objection to her ability to provide an opinion in the fields of marital family law?
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendy Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendy Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendy Adelson and Dan Markel in the 2014 timeframe. I was provided but didn't review thoroughly text messages between Wendy Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother, but most of their communication, I think, was by email, and I reviewed the emails that I was provided between Wendy Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendy Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Okay. Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendy, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendy Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine, because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going, and it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendy Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel, which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed, where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary, but then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage, so you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendy Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out on themselves, by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing?
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now, we're using the term time sharing. We also have, during the trial, heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
Okay. And so the term custody is not something that is used in family law proceedings any longer?
Not between parents. There's some, the term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time.
When Wendy Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markel from having?
Yes, to the people that are asking, this is the witness that was sat in the courtroom.
Substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markel from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now, for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So, in other words, when Wendy initiated the dissolution against Mr. Markell, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markell's motion to dismiss.
Hey, thank you so much, Carol Johansson 2807 for the super chat. Thank you, Metrix, Soap, and Mods. You hear that, Amy? And Sally?
The petition for relocation, and then he had filed a motion to enforce life as he would have liked to have seen it, and then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce. And then...
In other words, he was asking the court to enforce something that they had agreed on but hadn't been a court order?
Well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something, and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by a court or even put into any sort of formal document. So that was denied.
So let me understand correctly, he was asking for court authorization to be able to go over to Wendy's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just change their mind. So he was trying to enforce conversations that he had had with Wendy that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markell's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it, and he was basically saying that the petition for relocation was baseless and that the court should deny it, and the court said no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendy essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the June 21st, 2013 hearing, did Wendy Adelson and Mr. Markell resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendy waived alimony, they adjudicated child support, they put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator.
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances plus best interest. Kristen talked about that earlier. And you have to, it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court to say, hey, can you get her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change, and the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson-Markell case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No, they resolved everything. Temporary parenting, permanent parenting, support, property.
How many months elapsed between when the initial petition for dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial.
As of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
No, to the contrary, it was settled amicably, and everybody was moving on with their lives.
And quickly.
Yes.
During the underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adamson spoke about earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendy about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about the responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days. And then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of...
Again, why the hell do people get married? She's trying to take my retirement money. I'm not giving my records. You know. What? Anybody, tell me the upside. There's so much headache to it. Especially when it comes to this asset management stuff. In the event of divorce, what is the percentage of marriages that end in divorce? It's high. You know, it's high. It's not gonna happen to us. I love you so much, I love you forever. Never happened to us. A prenup? We don't need a prenup. A prenup would just be undermining our wonderful love. Our love forever. Bullshit, man. Bullshit, man. Anybody, tell me, what's the upside? What's the upside? Financially, emotionally, or whatever, if you want to make decisions based on those things. You know, what is the upside? Why would anybody get married? Is anybody getting married right now? Is anybody engaged? If someone's engaged, you know, maybe rethink it. You know, do you really need to get married? Why are you getting married? What is the number one thing that you're going to achieve by getting married? Now think of all the risks. Think it over. Think it over. Sleep on it.
A scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
if I need to do that, they could be company-held employment plans, depending on what kind of company, you know.
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140 something real estate properties all over the country. And that makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third party subpoena the management company. But that's an outlier.
Oh, I'd marry soap in a heartbeat. There's probably a service provider out there somewhere that could officiate that.
Let's just say you didn't have to do any of that, or none of that had to be done for Wendy Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool, where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
Okay. And aside from those two, I believe Wendy, was she deposed?
I don't recall seeing that Wendy or Mr. Markel were deposed.
Okay. Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Okay. Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, Gibbers means someone.
Gibbers was a funny name. I suggested it to Wendy as a nickname that she could give to Danny when he was being scary and threatening. I said, why don't you call him Gibbers?
Who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even after.
Hey lady, newsflash. His pleadings, extreme as they may be, were extreme because your fucking client was an extreme lunatic, okay? What do you think he's gonna do? Lie down and let this steamroll over him? No. And I've read Markel's legal speak writing, and I've read Wendy Adelson's legal speak writing. And the difference in quality, in terms of, there's a very special way to write something in a legal fashion. And Dan had it. Dan had it down as an art form. And I'm not saying this to like, oh, he was a brilliant legal mind. I'm just saying solely based on the writings that I've read of his were appropriate. You know, she keeps calling them verbose. That's not the case. They were voluminous. I almost made that same mistake. They were voluminous, but that was because they were in response to Wendy's extreme Visigoth-like sacking of the marital home. Wendy's, on the other hand, had all sorts of schoolboy errors. You know, when a judge reads something, you know what they really hate more than anything is embellishment. Excessive embellishment for effect. It's like, get to the point. I'm a judge. I don't have time to read this thing which you're saying the exact same thing in 3 different ways, because in your mind, Wendy and your team, that, you know, gives it more weight. It does not at all. Not when it's being read by a judge or anybody that might be reading it, for the matter that it's of which it's intended. There's no contest. So for this witness to get up here and say, "Oh, you know, his writings, they were so intimidating, and they didn't even make any sense. They were gibberish. That's why we called him Gibbers, because he spoke gibberish." It's not the case at all. And there is no way, 100%, that this witness or the previous witness has come into this cold, right? They've been prepped, assessed, molded, directed to paint this image that the defense is trying to put here. It's incredible to me that this is a good chunk through the second day of the defense's case in chief, and we still have not gotten to anything to do with Donna's intent to conspire and solicit and pay for and plan and scheme the murder of Dan Markel, which makes her guilty to first-degree murder as a principal, just the same as if she pulled the trigger herself. That hasn't been spoken of, not once. Not once to my recollection, and certainly not within any focus, weight, attention, nothing. What they're trying to do is say, hey, look, you know, the divorce, they got divorced, it wasn't that bad, and, you know, they were working it out, and Wendy was happy that, you know, Wendy had a get your groove back party. Hey, would you like to be invited to the Wendy Adelson Get Your Groove Back party? Yeah, with a machine gun. Unbelievable. Amazing. And these 2 witnesses, they're current lawyers of some considerable standing in the law community, apparently. I mean, you would be after 37 years of practice, right? You should be. If you're not, you're in the wrong fucking job. They obviously know that they're within the ethical guidelines, and anything that they might say that is not true doesn't matter because it can't be shown, can't be proven. But they are up here committing ethical violations. Maybe not on paper, but of the soul, definitely, 100%.
Words in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendy Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph, that he knew she had these accounts because he managed one of them, and he knew about the other.
Nose Whistler is, that's just ungodly.
Account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendy filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so dollars. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December.
Even his lawyer withdrew because he spoke so much gibberish. He was done. He was finished. We would prevail. So why would we need to kill him? Because, his lawyer withdrew. Hello?
Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied.
Mm-hmm.
Did my client, in the emails you review, appear to push back on Wendy and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st. And there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Or is it possible to undo this? And then Wendy responded, I think at the end of that, Mom, I'm at peace, I'm good. And then they dropped off. There was no more communication that I saw between them.
Certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want are third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help.
If you don't trust my advice, maybe you should get a second opinion. That sounds kind of hostile. Doesn't that sound like a fuck off line? A threat? Well, if you don't trust my advice, maybe you ought to get a second opinion.
You, and they can.
Sounds like what you say just after someone complains about the bill, right? You hand them a bill, and they say, "Whew, what? Can I just say, what is this? What is this $917 in phone calls? Who have you been calling?" And they say, "Well, if you don't trust my advice, maybe you ought to get a second opinion."
We can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand.
Have I been chewing on this live? I know I have done that very sparingly, and it was only nuts that I ate very slowly. And that was not years ago, it was months ago. I don't think I've been chewing on this live. I did have some egg fried rice, but that was way at the beginning, and I put the mute button. I don't know. I'll have to get some soup for tomorrow and slurp it right into the mic.
In my position, and maybe theirs will change.
Now, you were provided with a number of emails that Wendy was sent by her mother. Did you see?
You have an emu? Hello, Shiny? That's so cool. Hang on, let me read this whole comment. My emu makes cool clacking noises when I feed her apple. No lip smacking for her. Her beak is a pure tool. Amazing. Let me just check that I'm thinking about the right kind of thing. That looks like a fucking ostrich, isn't it? Emu bird. Wow. Oh, that's cool. Look at this one. Oh. Like, is that common? How does one come into owning an emu? Oh. Where is it? There it is. Look at him there. Isn't he great? Ah. He'd be doing a better job at this defense than Mr. Zellman. But yeah, it's real big, right? Flightless bird. Wow. So cool. Respect. What do you call it? Or her. Or, yeah, what do you call her?
Evidence that Wendy shared those with Kristen Adamson?
I saw no evidence that Wendy shared them.
Okay. And did you speak with Ms. Adamson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendy Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for, and that was to last 3 years, and then it went into 50-50. I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, you know, the
2 emus.
division of child care, that sort of thing.
And without going into...
They're not married, are they? Tell him to conceal his assets. What did I do with that watermelon rind? I can't let her know about my watermelon rind stash. She's gonna take 50%. I'm assuming that they would eat something like that. I don't know. Should we ask AI? Can an emu eat watermelon rind? You see, these are the kind of questions that you're never going to get answers to on Carl Steinbeck's channel, okay? Yes, an emu can eat watermelon rind, and it's generally considered safe for them to consume, offering more fiber and nutrients than the fruit itself. Well, I fucking hit the nail on the head there, didn't I? True Crime Metrix, ornithologist, bird expert, that's me. However, it is crucial to offer only small pieces that have been washed thoroughly to remove any potential pesticides or fertilizers, as these residues can be harmful to the birds. You see that? Hello, Shiny? Wash the watermelon rind. I'm gonna laugh so hard if Carl Steinbeck's next video has a thumbnail that says emus and watermelon rind.
Too much detail. Child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, child care, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markell had asked for sole decision making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision making, which is extremely difficult to do. The only time a parent gets sole decision making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markell get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that, by agreement.
And you mentioned keeping the boys kosher. Wendy Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendy Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Carol tells us if we could see how many more papers Zellman has to shuffle through, we could get an idea of how much longer it will last. And I can tell you it's been far too long already. Completely useless lies, obvious. Yeah, I couldn't say it better myself.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendy Adelson...
Yeah. Did Mr. Markel get the children on Yom Kippur?
required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say, you need to go to your therapist and follow their advice.
Was Wendy Adelson required, pursuant to the settlement?
So you're going to educate the highly educated, Harvard law educated, Cambridge educated, FSU law legal professor. Is that correct, ma'am, or are you in fact speaking bullshit? Don't forget the Hebrew University in Jerusalem. Is it in Jerusalem? I think it's Jerusalem. Founded by Albert Einstein when? In July 1918, which, at least in the last century, and this one now, I guess. Yeah, sometimes people write the date in a year, right? And they omit the count of the centuries. So 1918 would be comma 18. You know? Meaning that the Hebrew University was founded by Albert Einstein in July 18. I always thought that was a funny coincidence, you know? Because Dan Markel was murdered on July 18th.
An agreement to
And you can look that up. That is a checked fact.
equally split time on each of her children's birthday with Mr. Markel.
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements because kids don't want to see their parents fight every birthday.
Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement?
No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendy a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendy Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases?
Veronica Schneider says, somebody just posted a pic of the divorce attorney and this boring bleached witch chatting it up, sitting together at the courthouse, perhaps discussing how they will spend their Adelson fees. Yeah. I'm shopping for cars. I'm thinking something sporty. Something Italian.
Is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendy Adelson?
Yeah. Yes.
Now, later,
But it's very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual.
Pallets, come on. I think it's time to give those guys some roast beef. Roast beef.
Requests, and at the end of the day, he gave up on those, and they got a very typical marital settlement agreement.
so from September of 2012 until the final judgment, July of 2013,
Yeah, what are their names and where the hell do you live? We want pictures of the emus. Come to Discord and show us your animals. We've got a whole animal section. It's called Metrix Pets. Metrix Pets, and it's on Discord. Link in the description. Everybody join Discord. Everybody join Discord, where we will have emu pictures very soon, I'm sure.
as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later,
No names for the emus, okay. Well, I insist that you call one of them Metrix. We're still wondering when the first puppy is going to be brought home called Metrix. That's going to be a point of pride. That's going to be even better than getting a shout out from Paul from reporting live from my sofa. A puppy called Metrix. Do you think we're going to see an increase in chocolate labs all around the world called Soap? I think it's a great name. I've always liked it.
the payments for Mr. Markel were due within 60 days, so that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of...
No, don't name them Wendy and Charlie. That's horrible. Name one Metrix and the other one Professor Markel. And they can fight over their watermelon rinds.
October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did.
Okay.
And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just... she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendy to do anything about relocation?
Not that I recall.
from your review of the emails and the pleadings, did it appear my client accepted that Wendy was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendy waived her right to appeal that by agreeing that the relocation be dismissed, so.
Now, prior to final judgment being entered, would Wendy have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
She could have.
Would there be anything improper with Wendy or her family through Wendy offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen $35,000 to get whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide-ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation, so that's routine.
Nothing unusual about
Routine.
that. Okay. Now, you testified earlier that you were provided text messages between Wendy Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it was a few months period, even after these motions had been filed that kind of upped the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
It was much more amicable than other cases. They were very flexible with each other. Does everybody remember listening to Dan Markel's voicemail on the morning of his murder, where he was asking Wendy if she would let him pick up the boys to take them swimming before his trip away to New York, and that she could pick up the boys from his house and he'd have them ready for her at about 4:30 or 5, as far as I remember. Oh no, I forget the times, but don't worry about that. Totally reasonable, very considerate. Wendy's response was, what was it? No. I will be picking up the boys at 3:45, so your little swim idea is a no-go. It was worse than that. It was absolutely horrible. It would send me into a rage if anybody spoke to me like that. He flew into a rage. He was all red and puffy. Jeff Lacasse.
Now, you indicated earlier that October 31st, 2013...
I know, Amy. Isn't that just a horrible way to put it? Swimming is a no-go. What kind of energy does that convey? Horrible. Hostile. Dictatorial. Dictatorial? Dictatorial. You know, what am I trying to say? I'm tired. Like a dictator. What is the word for that? Dictative, I suppose. Oh, it was just horrible. Horrible, horrible, horrible.
Kristen Adamson filed a motion for enforcement.
Correct.
Soap. Mark the calendar. Mark the calendar. We're getting a rooster. Not just any rooster, a good rooster named after us, Metrix. How fucking cool is that? Oh man, that's great. That's great. What is the date? September 3rd. September 3rd. Had a good rooster named after me. That is a huge point of pride. Thank you, Hello Shiny.
You mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so that she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief didn't include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness?
Hello Shiny, I just had a look at your channel and you have been drawing watermelons. Check it out. Oh, we gotta do it like this. 7 years ago, but there they are. Oh, we can't lose that. No, we can. We have that one twice. There we go. There we go. Everyone check out Hello Shiny's page for the how to draw watermelon videos. And those aren't just any hands. Those are Hello Shiny hands. Good job. Funny that should come up, huh? Look at Donna. Oh, I got to screenshot that. Let's move that comment in a moment. Got it.
An approach with courts. One states demonstrative A, specifically page 338.
Oh, Michelle's back. Oh, Michelle.
Is
It's
that
been
the
quite a ride.
October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of...
Does she have blue lenses like Johnny Depp, or is that just something reflecting in her glasses? Because when she put her head up, the blue went away, the blue tint.
Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause, and under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support the former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendy is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line, but then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here, she's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
In the scheme of this dissolution and the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markell?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markell emailed the parenting coordinator and Wendy Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that Grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendy in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendy to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not.
Carol says, the emu sound fascinating. That's interesting. The male sits on the eggs. It's the same with emperor penguins, Carol.
Asked for that relief.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kids said something like, Grandma thinks you're stupid, or something like that.
Did Mr. Markell file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was...
I think it's so funny that Zellman is asking these questions as if he has a point. You know, it's kind of funny that, you know, Daniel Rashbaum, charlatan as he is, you know, not counting his opening or closing, because that was just very much like this, like, what are you saying? But, you know, in his actual questions, I mean, it wasn't as he was within the area. He was. You can say that he was at least addressing the probative elements. This is I do not understand what we are watching. I mean, I kind of do, but I don't know why they think it's a good idea to have this tactic. They've not addressed anything at all. They're pissing the jury off because they don't understand. They're like, what is this? Why are you boring us like this? This is a terrible tactic, and I think it was Kosher Style that said it earlier. I mean, maybe all they are hoping for is a mistrial. I mean, what fuck up is it going to be today? We've had 2 days of sequestered witnesses that have been privy to testimony. Does anyone think that the defense are not going to piss off Judge Everett tomorrow? Because I think they will.
As the certificate of service, which is the bottom of the motion, you file a certificate that says where you have sent this document, to whom you've sent this document, and it went to Mr. Adelson's new lawyer in December.
Mr. Markell?
I'm sorry, Mr. Markell's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after.
You see, Ashley Rose knows. I didn't even see this comment before what I last said, but Ashley Rose 7100 says, True Crime Metrix. What is the point of this testimony? I'm falling asleep over here. Is Zellman just trying to distract by deflecting that this was all Wendy's idea and not Donna's? It's a clouding of the facts, right? It's pushing back against that this was a divorce and a litigation process that was unresolvable without a murder. That's what it's trying to do. That's what it's trying to keep the energy off. But, you know, something that Judge Everett has called for today is at least the discussion. He may have called for... No, I think he at least demanded that they start the conversation about whether or not Donna Adelson would testify. I don't know that she needs to make a decision today. I don't think she'll be called today. Certainly not. I mean, I know that we're before lunch. I cannot see Donna Adelson taking the stand today, but maybe tomorrow. Maybe tomorrow.
After the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendy had these other financial violations. And then she referred to the Schwab account that you've heard about, and a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendy. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he...
Yeah, I kind of drew on this point earlier, Carol. Carol says he's hoping to piss the jury off enough that they just want to be done, stop listening to anything, and vote not guilty because they will feel guilty for not listening and wouldn't be able to convict. I suspect that may be a tactic. I really do. I suspect that is quite a standard tactic that some defense counsels utilize. if you can make a jury switch off. We saw a similar unusual thing in the Chandler Halderson trial, where in closing, attorney Vera accused the jury to their faces of reviewing case information when they had been instructed not to do so, which was a risky move. You're all liars. She didn't quite say it like that. She says, I hope you didn't do that, but I'm going to be realistic. And with that, she was banking on someone who did review case information when they weren't supposed to. And this creation of, this idea of guilt creation to the jury is an interesting one, because it is a serious decision. It is a serious decision to sentence anybody to the rest of their life in prison and come back with that not guilty verdict. And if there's something weighing on your conscience as a jury member, whether it's because you weren't listening all the way, or whether it's because you reviewed case information when you were instructed not to do so, if there's some guilty thing on your conscience, that can be a huge emotional, point to make it difficult for a member of the jury to commit to a guilty verdict, right? I think that is probably taught in law school as an aspect of that a defense can use.
Claim to have avoid paying Wendy Adelson as he'd been ordered.
My recollection is his defense.
What's your sandwich choice, Veronica? I like talking about sandwiches. Was there something I missed? Well, I don't see anything recently. Can you tell us again? Would it be too much trouble to let us know what that was? I would really love to know. Yeah. Just as soon as anybody supports the channel on PayPal, we will be making a special trip to the Posh Delicatessen, where we will be picking up the ingredients for the Harvey Adelson sandwich. Please do support the channel on buymeacoffee.com/truecrimemetrics or the PayPal link. That would be great. Everybody. Couple of bucks. Couple of bucks, $20, whatever it is, we appreciate it.
Was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that to know what the then value was. But those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then, according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another or something like that, and it wasn't legally supportable.
That's not a valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
Okay. Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adamson referred to. It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud. So if you find out later that they had won the lottery before you and didn't disclose, or that they had some stash of gold bars somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle to
Sure,
overcome.
and it had to have impacted you.
Okay.
In this instance, it was clear from Mr. Merkel's own motions, he knew about these assets. So I think his fraud allegation.
Kosher Style got divorced on February 14th. Best decision you ever made, Kosher Style. In fact, anybody in the chat right now that's married, get a divorce. File today. And then never get married again. You'll be way happier.
And was completely baseless.
Now, in some of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did the January 31st response, and then he did the motion against Wendy on the financial issues February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and a number of phone calls wasn't required. He was asking for, there was some right of first refusal. He didn't like that when Wendy's parents would come to town, that she would maybe go have dinner with friends and let them spend time with the kids. Or she would let them stay home from school so her parents could spend time with them, and they were little babies. And he didn't like that because he wanted to be able to go to the child care during her parenting time so he could see them every day. And I think the child care person had asked him probably not to do that, but he wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
And is that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful. Yes. Yes, it looks like on April 11th. Nope, that's his response. Let's see. Yes, it was before it was based, my recollection was correct. She filed a motion to dismiss on March 10th. To dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
Motion?
Correct. And then that was all set for hearing for May 15th.
Okay. the complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like.
Ashley Rose asks, do you think Donna critiques Josh's lawyering at the end of each day, or that she's insulted him up to this point? No, I don't. Donna and Charlie definitely share this thing with confirmation bias, right? They want to believe. Donna wants to believe the trial is going in their favor, just like Charlie wanted to believe that the bump was a Latin king, right? And actively shaped the events to support that ideology, because the idea of the bump being an FBI agent would affect his self-image so badly that that would be hard for him to accept. That would be proof that his plan wasn't perfect and that he's not smart at all. Donna also, from her correspondence that we see, she thinks this is going well. And Zellman is probably explaining the fuck-ups away as this is perfect for a mistrial or something like that, And hey, even if you are guilty, it's going to be easy for you to do an appeal based on ineffective assistance of counsel based on my obvious inadequacies. Yeah, no, I don't think she's grilling him. But then again, she does it in a backhanded way. A bit like when Charlie was like, I wouldn't worry at all. I wouldn't worry at all, about anything. Donna was like, well, yeah, okay, good. I mean, if your theory is correct, because, I was thinking of someone else. She does this kind of very, around the houses kind of criticism. So I don't think she's getting in the back there and having some meeting with her counsel and saying, what the fuck was that? Why do you spend half the day shuffling your papers, Zellman? No, I don't think there's any of that. I think she's making herself believe that this is going well. I think Zellman is probably selling the premise of angling for mistrial, or at least safeguarding her room to maneuver for purposes of appeal should that verdict come back guilty. That's what I think, and thank you for your question.
But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made, well into this very long motion, was he brought up the stupid allegation from November, and this was the end of March.
Oh, okay. I'm so sorry for being so behind in this chat. Veronica Schneider's just got back to us and says, I just said I was thinking about what to get for lunch. The Harvey comes with a pickle on the side, but the Honourable Everett comes with a side of smoked turkey legs. 16 of them. 8 full turkeys died for that meal. 16 of them, 16 turkey legs on the side. A side, yeah, can I have that with a side of 16 turkey legs? Beautiful. actually, whenever I do eat a roast turkey, I stay well away from the leg. I don't give a fuck about it. Give me the breasts. Give me the breasts, and that's it. You know, there's all this stuff in the turkey leg. Chicken leg's better. But yeah, I guess I'm a white meat guy, right? White meat guy.
So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show material and substantial change in circumstances and that it was in the best interest, and there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in his motion, he says, I don't know if this is true or not. I don't know if Wendy was present or not. But I would like Wendy to make it stop if it's true.
Did the grant this motion, the March 26, 2014 motion that the state has called the grand...
Oh, fuck.
Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
Where
Prior
were we?
to final judgment being entered, would Wendy have...
All right, we're going to have to skip to cross. We have no choice now but to skip to cross. And thank God. Amy, you're getting your wish.
Stupid allegation from...
Or are they going to... What happened is I was going to pause it to read Kosher Styles' comment, but I accidentally clicked the timeline, and we went back, and I have no idea where we were. But I had a feeling that they were going to go, oh, I see boxes. What's in the box? We got to know what's in the boxes.
In particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
It was about 3 years?
Yes, including an appeal.
Your Honor, may I show the witness the demonstrative?
You may.
May I show the witness the demonstrative? Hello, Soap. How you doing? Everything okay? Enjoying your rest? Hello. Okay. Good job. Good job. Yes. Maybe sit down here on the cool tile. That would be nice.
Volume 1. Volume 2.
Good job.
Volume 3. Volume 4.
Oh, look at all the stuff. We got so much stuff.
There are questions.
Demonstrative is the right word because, oh look, Judge Everett's got a hold on this tactic. Is there a question pending that you're gonna pull all this shit out for, that you just want to overwhelm the jury?
Volume 4. Volume 5.
There are questions of the witness.
Do you recognize this file?
Judge Everett is all over this defense, isn't he? Is there a question for the witness? Judge Everett knows the score, okay? He knows that Zellman wants to pull out this huge stack of paperwork, volume 4, volume 5, volume 138, and just build a fucking wall of the divorce case in front of the jury so that they go, oh, well, that looks really complicated, so not guilty. Otherwise, I'm going to have to read all that shit.
Yes, I think I forwarded this to you.
And are these 10 volumes
It's ridiculous, Daphne. Daphne says, what does this other case have to do with the Donna ordering the hit? Exactly. The entire defense case in chief has not addressed that once. Not once. In almost 2 full days now.
of a hotly contested relocation case?
Well, and I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000, so this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal, so perhaps only one of those volumes got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
Please sit down, Ms. Bailey.
Horrible glasses. Georgia Kaplan will teach you how
Can
to
you
pick
tell
some
the jury
glasses.
what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I have the...
Members of the jury.
Man, okay, Georgia's had enough. Judge Everett's had enough. I don't think I've ever seen Judge Everett once refuse a request from the attorneys to approach. Not once. I don't remember. I could be wrong, but just on my memory, I think he's always allowed that. And he's had enough of this. Let's see that again, because these are historic moments we're seeing here.
Gosh, Judge, what's the relevance? Object.
God, do you hear the frustration? Not objection, relevance. Gosh, Judge, what is the relevance? You know. One more time. Beautiful. Good objection. Love the style of the objection. And Judge Everett.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
No.
Judge, we're entitled to make a record. I believe
Did the witness laugh?
have-
Did the witness laugh? The witness laughed at the judge for saying no to the request to approach.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I have the...
Members of the jury, the bailiff will take you to the jury room.
Oh, here we go. Here we go. Boom! Get him, Judge. Get him! He's kicking the jury out because he's about to bring down hellfire. Hellfire on the defense.
You may be seated. The relocation issues within
Chocolate Thunder. Is that what we're calling Judge Everett? Chocolate Thunder knows this defense is full of shit. Gotta write that down. Chocolate Thunder. I love it. Chocolate Thunder. Sounds like an album.
this this case are certainly relevant as to a separate other
Oh,
case.
I need the full
You may be
sentence.
seated. The relocation issues within this case are certainly relevant as to a separate other case. What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witness has identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendy Adelson and Mr. Dan Markell.
Kappelman, any other argument on this issue?
Just relevance, Your Honor.
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce files certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
Whoa. I'm sorry. As you may have heard, Soap was freaking out about something. I need to hear that whole segment again. I hope you don't mind.
You may be seated. The relocation issues within this case are certainly relevant as to a separate other case. What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witness has identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendy Adelson and Mr. Dan Markell.
Kappelman, any other argument on this issue?
Just relevance, Your Honor.
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce file certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
Yeah, just to display it in front of the jury.
It's brief.
Ms. Bailey, please step out of the court or the courtroom doors. If you can radio Deputy Bunk to leave the jurors in the room, please approach.
Wow. Very different format to the trial, huh? Very, last time with Judge Everett, which was the first time we saw Judge Everett, he entertained Rashbaum above and beyond, gave him leeway, seemed to find him charming and comical and those sorts of things, and really there wasn't personality friction between the judge and Rashbaum like what we're seeing here at all.
Do not make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. The jurors using the restroom.
They are.
Please use the
again.
restroom or stretch your legs if you need to. We will continue with the witness after that.
Right. It's 1:15 in Tallahassee. They're pretty late for lunch. Good. They might have a really long lunch break and I can cook my beef stew. Portuguese style. I gotta send a picture to Black Eagle. Black Eagle is a big stew fan. Out and about. 4812. I gotta bet those numbers. What are we gonna put on a mug? Chocolate Thunder. I bet it's Chocolate Thunder. Or Chocolate Thunder pissed.
All rise, you're entering the court.
Everyone can be seated. Please continue with your examination.
Thank you, Your Honor. Ms. Bailey, how did the Adelson-Markell divorce?
Which NFL winning you have for us? The Chiefs are going to beat the Dolphins. But I got that from Charlie Adelson.
Compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to.
Easy case, easy question. Hello, Shani 8475 has a question or a statement. Dumb question. Okay, it is a question. Dumb question. Can the state call Donna as a witness? Everyone is talking about whether Donna will decide to testify, but I want to know if the state can make her get on the stand if they want to. They cannot. No, that's not going to happen.
Many.
Did it look worse than it was because of the way in which Mr. Markell's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think, and responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose. They were hyperbolic. He used a lot of inflammatory language. But when you really looked closely at his...
everything she's saying here is false. I mean, obviously, I have not read the divorce file in its entirety. That would be 10,000 pages. And I just, I think I'm going to save that pleasure for retirement, Once I get that nice front deck, little hammock going on, I'll pull out the Adelson-Markell divorce file and sip a pina colada. Just joking. I would never drink a pina colada.
Requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine
Little bit of bedhead on Georgia today. I like that.
about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case
My gosh. My oh my.
matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world? Do you
Well, that's
agree
one
with
reason-
that? Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case
Whoa,
as
whoa,
a
whoa, whoa,
lawyer
whoa, whoa.
might be routine?
One
whereas
second.
a-
Because
have pretty good.
I love nothing more than Georgia Kappelman being frustrated and, making her point over no point. Let's have a look at that again.
Judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world? Do you
Well, that's
agree
one
with that?
That-
Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case as a lawyer might be routine, whereas to the parties it's the most important thing in the world?
To some degree, that's one reason I called Kristen, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm, and I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
But you're
pages in
not-
front of me.
Fuck
You're not
yeah,
in the
now.
mind of
Isn't she good? I mean, what are we witnessing here? My favorite lawyer, by a million miles, is this woman right here. It's absolutely amazing. See it again. See the whole fucking thing. Oh, we don't need to do the whole thing again.
it.
I would say annoying more than emotionally charged.
You would not say
Hang on.
that?
Hang on,
Is to
hang on.
call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court, it can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be.
Amazing what she does with tone, right? She's a very... It's funny, you know, because in some ways, Georgia Kaufman seems stone-faced, right? Not rattled, not over-emotional, about the facts, and measured, and all the rest of those things. In some ways, she seems like she has less theatrical emotion in her performances, if that would be the right word. But actually, when she turns it on, she's very high up on the on arguing things from this indignant, emotional side, you know, just with the tone and the body language and the facial expressions. So happy that we've got face cam on these later trials. We didn't have that in the first couple.
But in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants.
Did you see the blonde lady? The blonde lady on George's left, hidden right now, but we'll reveal her. She's creasing in the gallery.
Might not.
Look at her face. Look at her face. Screenshot. I'm just going to save that. I'm going to make that the background to my cell phone. Look at it. Georgia, you bring it home. You bring it all home.
I think it's stinky at all. Do you get the reference?
Hang on. I might have a stinky bag of garbage, but the garbage man might not think it's stinky at all. Do you get the reference? I don't. I don't want to.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big
Look at
deal
the
to
blondes.
us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
derived.
that person,
I didn't grow up in Iran. What is going on now? I didn't grow up in Iran.
it was a reason to commit suicide, right?
Apparently so.
Aren't these...
Yeah. Hey, for all of the anti-marriage people in the audience, if divorce is so shameful in your culture, religion, or upbringing, or whatever it is, don't get married. You don't need to. It's not ever done anyone any favor. It's only create. Think about all. If we take everybody that ever got married ever, and we added up all of the good things that have happened to those people that happened because they got married, right? And then on the other side of the scale, we looked at all the marriages that have ever happened, and then we added up all of the bad, horrible, hurtful things that happened because those people got married. Which side of the scale do you think would weigh the most?
These issues raised in these pleadings, potential fuel to make people upset.
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting?
I would never do that, Derek. All I want to do is tell her husband how lucky I know he is. Pursue her? No way. No way. We're not worthy. In the words of Wayne's World, we're not worthy. But goddamn, I hope he knows how lucky he is. Way to score a perfect 10.
To grandma?
You'd have to ask grandma. I don't.
Exactly.
It shouldn't have been. There was no proof.
It shouldn't have been, in your opinion.
In my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markell wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
I think on that issue, he clearly had the assets. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay. Well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And
I
Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
Yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. If no question, then move to strike.
I'll rephrase it.
Was the objection again?
It's an improper.
Derek says, I love how scathingly mocking Metrix is, but when it comes to Georgia, she can do no wrong. She does no wrong. It's not it's not bias. It's not bias. You know, I said that I don't, you know, that her jacket today with the belt combo is not my favorite. It still looks good, and it's appropriate for the task ahead of her. It's just not my favorite. That's about as close as you're going to get to a Georgia Cappleman criticism from me. But I am always honest, and, you know.
Comment on the witness's testimony.
So, quiet.
Stay and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendy. Jail is not a possibility on that. But you don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support, and if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, you know, Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 due Wendy. It was only.
Hello, Shani. Charcoal dog soap. Well, I'll check that out. I still got about 2 more baths of this this expensive one. She only needed one scrub, and she was good as gold. But yeah, okay. I'll keep an eye out for that next time. Charcoal dog soap.
That could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers?
You see, it's not just me. Veronica Schneider 305 says, I am straight, but I would go gay for Georgia. I would be the biggest lesbian in all the land. Well, you would be, unless I were a woman. And then I would be the biggest lesbian in all the land. That'll be my new thing.
Answers to her mother.
I don't recall that. I don't recall saying that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any?
Yeah, that's the thing. That's exactly the thing, Carol Johansson 2807, who says, I'm straight, but I have a crush on Georgia and Sarah, but also on Detective Corbett and Pat Sanford. I just like smart, professional people who do their job really well, and they're more attractive to me. Exactly. That is exactly my thing. You know, I will obviously vouch that Georgia Kappelman has the most fantastic, beautiful hair in the world, but, you know, she's not really my type. Blondes aren't really my type. At all. Not at all. But the thing that's most attractive to me about Georgia Kappelman is the fact that she does her job so well. Smart professional people who do their job really well. And that's the thing. She takes care of business. And that is more attractive than how anybody looks. You know, I don't think it'd work on anybody. You know, there's a limit. You know, the looks are important too, but you know, smart professional can make someone that wouldn't be typically my normal type a front runner, and that's damn hell sure what she is, because of her professional nature. And that makes me feel a lot less objectifying of her. You know, I'm not drooling over her because I find her so amazingly physically appealing. It's because she's good at her job. That's the primary thing.
Emails from her
And the perfect hair does not hurt one bit.
at all post settlement.
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post denial, post stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is,
Oatmeal bath. I did that once. Man, that was amazing. That was great. Everybody should bathe in oatmeal every day. Yeah, she doesn't really have skin problems as a rule. I think it was a seasonal thing, but good to know for the future, just in case. Carol Johnson, not Johnson, Johansson.
his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well-
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended, if that's...
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markell filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markell amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markell's murder, litigation was still ongoing in this case.
It
Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection or call for speculation.
Overruled, the witness has provided an opinion, the state
Well-
will cross-examine.
I guess my
It's-
response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen, because we never got to that point, right?
Clearly,
Because he was murdered.
clearly.
May I have a moment to confer, Judge?
Go ahead.
Oh, it would have been settled on March 15th. How do you know that? There could have been a zillion reasons that it would have been continued. Both of these lawyers have done some reputational damage to themselves today. But that's because they made a deal with the devil. They chose a quick buck over a lifelong reputation of integrity. But they're both about to retire anyway, so I guess they don't really give a shit, right? What is this woman, 62, 63? She's been practicing for 37 years after coming out of law school, so when do you come out of law school? 26, 27, then maybe a couple of years as, what do you call it? You know, what do you call it? Not apprentice, but residency, or you don't, that's medical thing. You know, let's say she started working when she was 29. What's 37 plus 29? 66? Is it? Let me just check that. Yeah. 66. Could she be 66? I think she could. I think she could be 66. So, if you're about to retire, I mean, nothing's going to affect her, really. Even if by some extreme standard she were shamed and reputation ruined, she's not doing it at the beginning of her career. You know what I mean? Nice little bonus right at the end of the career, courtesy of the Adelsons, to come in here and throw shit on a dead man.
Your Honor.
Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
There was no new information. I'll say there was no probative information, or from you. So what the fuck are either of you doing here for the whole morning and a late lunch now? Fucking hell! What a shit show of a defense this has been. And I really expected something. I'm surprised that Jackie Fulford hasn't taken more of a handle in this. Very surprised.
To be recalled at any point.
Fucking hope not.
Potentially, Your Honor, but she's free to go about her business.
You remain under your subpoena. Please do not discuss your testimony with any other witness in this matter. Have a good day.
Yeah. And don't watch any
Jury, at
others.
this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom.
What is a let? Carol says, yes, you're not a let, Frank. It's okay, honey, but everyone I think that respects the course of justice and truly cares about the Markel family finds these prosecutors and professionals attractive. Damn hell straight. But what is a let? Is that a typo? You're not alone. Yeah. I think it's, yes, you're not alone, Frank. I got it. Ooh, she's really arrogant. She thinks the whole trial is about her. Pfft, yeah, that was a horrible witness. Kosher style, good comment. Miss Bailey is nervous. Her body language is showing it. I agree. Nervous and a little bit indignant. Everyone is pissed that I law clerk. I love that Soap is here with us. She's darling. Oh, she is so good. Maybe we should watch a Soap video to calm us all down before lunch. Before we all go out for a Harvey. A foot-long Harvey. Maybe 1 year. Most jump right in. Maybe 1 year. Most jump right in. Okay. She's not straight, she's a con. Great point, Georgia. Perspective from the two parties on one divorce, genius and obvious. Many would miss it. Genius, common sense. Hello, Miss Bailey. Hello. Yes, Miss Bailey is looking more and more anxious and greasy as we proceed. She's now talking with her hands, her head, her shoulders, really trying to get her untrue points across. Yeah, there was definitely some... I mean, Georgia laid on that pressure. Hey, if Georgia Kappelman spoke to me like that, I would crumble like a leaf in October. Man, intense. But I'd also kind of like it. You know, I'd be like, yeah, make me crumble like a leaf in October, baby. So now she encourages her clients to take it to court. But earlier she encouraged them to work together, mediate, and cooperate. Those are incongruent statements, Miss Bailey. I think what's congruent is that she's charging money for her opinion, right? Like any lawyer. Other channels say they're worried about putting Donna in stand based on Georgia's temperature today. Wendy's police interview victim advocate coming up this afternoon is Marisol. Really? Wendy's police advocate is coming up this afternoon? Sarah Latour. They're back in 25 minutes? Fuck. See, that's what I get for being behind. So, no beef stew, no walking the dog. Oh, she's all depressed and looking at me again. I'm gonna have to take her out for those 25 minutes, I think. Kosher style, they're scared of Georgia. They should be. I zoned out with this witness, thinking if I should date Georgia or Judge Everett. Decisions. I know, right? Well, you got to go on compatibility. Now, if you find yourself with a craving for butterscotch at the end of the day, every day, go with Judge Everett. You'll have that common ground. And common ground can really help a relationship, whether it's butterscotch or any sweet treat. I wonder if we could come up with a Georgia Kappelman sandwich. Actually, that just sounds like my dream come true. A Georgia Kappelman sandwich. Yeah, what would that be? And why? I think we could do it. Follow us on Discord for the Adelson cookbook, which we will be putting out as a physical product, hopefully by this Christmas, if we can get the support. Please support the channel on buymeacoffee.com/truecrimemetrics, PayPal me /truecrimemetrics, or there's a bunch of other ways. All the ways to support the channel are in the description for the video. If you want an Adelson cookbook, what are we going to have? We got to do the Maine lobsters. Now, I'm not going to bother getting them from Maine. I'm not having lobsters flown over, but I can get Portuguese lobsters, which are just as good. Just as good. What else have we got? Let's go through the list again. Maine lobsters. We're going to have to do a chili for the Skyline chili. Skyline. What else? Paella. Banana bread with, how did Dan like it? With chocolate chips, not nuts. Choc chip. It was choc chip and something else, wasn't it? What else we got? I can make a hell of a pie right here, but I gotta go and get the special dish, you know? That big old dish, we gotta do it in a special dish. There's no way I'm cooking fucking Adelson pie in a fucking regular frying pan. That just wouldn't do it justice. I've already written this list down 100 times, but we gotta go through it again. What else we got? We got... Maine lobsters. If anyone doesn't know this game, you know, there's a whole bunch of food. Sushi. Sushi. We already did the burger. Where's the burger? That was a tasty burger, man. You know, I made that when I was still living in the van, and it would look like it came from a fucking 5-star gourmet kitchen. How do we find that? Where is that picture? I don't know. Or maybe it's on my phone. Let's check. Did I have this phone back then? Probably. Oh, that was a good dish. That was a good dish. Oh, yeah. There it was. How do I get this from my phone to the computer? I'll send it to Amy. If I send it to Amy, then I can put it on the computer. Actually, it doesn't look that great on the photo. But we can do another one. What else we got? What other food is mentioned in this saga? Save as burger. Boom! It was a little tall. I don't even remember what was on it. Pretty standard. Pretty standard. What else? What else can we talk about? Any more Adelson? Soap, give me a minute. Stop whining. I hate that. I hate it when you do that. It's so passive aggressive. If we were married, I'd be looking for a divorce right now. Performance. Jodra is proper theater actor. Oh yeah, that's a real good point. Lead role. Rashbound was a sitcom next door neighbor character. Hello, Shiny. Like, I really, you've got some great like observational humor. I think it's fantastic. We read out your comment. I don't think you were here at the beginning, but we read out your comment earlier. at the start of the show about the costume AI. I love that. I love that. Yeah, she is after Marisol. Yes. The one with the skirt you hated. Yeah, I know who Marisol is. Oh, no, you're talking about Sarah. Right. Yeah, the stroby skirt. Of course, Marisol's from Miami, so she only wears pantsuits. Definitely a pantsuit girl. Maybe we should skip this forward so we know when we come back. God damn it. Why, the only reason I'd want a wife is well, maybe there's a couple of reasons, but one of them would be to walk the dog at a time like this, because I'm going to have to go out. I'm going to have to go out, and I could just send my wife, right? Marisol is the Miami attorney. Yeah, we know. Talk really fast. Your Honor, I am representing Donna Adelson, who is seated in the chair next to my left. Slow the fuck down, you motor mouth. Marisol Descalzo, yeah. That's not the victim advocate, it was Donna's lawyer. Correct. Yeah, apparently they're both coming on, Veronica. The victim's advocate name is Sarah. I don't recall her last name. Her last name is Latour. And she's doing real well, apparently. We saw some photographs of her recently, doing her thing, doing her professional thing. Kind of surprised that she's being brought into Donna's trial, though. Donna, previous attorney, blah, 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 blah. I gotta try and get through these comments. Yes, I meant to say you're not a lech. Oh, okay. What's that? Like someone who, like, I've heard that word on TV, but we don't really use it where I'm from. That's like someone who, like pervs over women, right? Like rubbing their thighs and breathing down their neck. Yeah, I'm not that kind of guy at all. Banana bread, paella, Harvey pickles. Just think what Georgia is going to be like with Wendy. Ooh. Well, I said this the other day that it's a belief of mine that Wendy might be the only Adelson smart enough not to testify in their own defense, and if she does not testify in her own defense, we could have already heard the last of her. She might have her trial and not testify, which means we will not see her on the stand again. Which means we will not have the pleasure of witnessing Georgia Kaplan tear her ass up. Bourbon butterscotch cookies, God. I'm glad Judge Everett isn't reading this because he'd be shedding tears right now. And a bonsai tree to decorate the table. Yeah. Maybe at the back we can have tips for caring for your bonsai. I'm gonna write it down. Bonsai. I've been saying Harvey Aardvark at least once a day, just for the hell of it. Harvey Aardvark, it really has a nice ring to it. I tried to sell a t-shirt with the Harley Davidson logo, but I changed the word to Harvey Adelson because they sound exactly the same, and at first glance you don't even notice. I tried to sell that as a t-shirt and they said copyright, which, fair enough, I guess. I was like, did you not read my edit? Sushi and pizza. Yeah, man, you know, pizza. I know how to cook a fucking bitchin' pizza right in your home oven. One of the best I ever had. I blew myself away. It's all about using grated mozzarella. Not the fresh kind. It's got too much water content, so it makes the bread soggy. But if you use the grated kind, that's real nice. And there's some tricks you can do with when you make the dough. You gotta add like olive oil to the dough recipe, and also something else that I don't remember right now. I got a new phone. Yeah, but it was before the burger, as we now know. You need the bio dish for sure. Yeah, we're gonna do saffron rice, proper paella. You know, and Spain's only over there. You know, I'll go to Spain to get the real ingredients. Defense witnesses were Wendy's face level of aggravating. I agree. Michael Murphy knows. Soap, will you just give me a minute? I know you want to go out. I need to get through the comments. I will wait patiently for you to walk, Soap. Yeah, but you know, the court won't, will they? We gotta be here. We gotta make sure it's all running smooth. The Mchinda sushi roll. Her name would look good as a menu item, actually. The Mchinda something. The Mchinda yakisoba. I could go for some yakisoba right about now. We had those noodles yesterday. Man, they were no good. They were no good at all. But tonight we're cooking that beef stew. By special request from our good friend, Black Eagle. Maybe she can send us some Maine lobsters. She lives in Maine and has a lobster farm, as far as I remember. Send us some lobsters in the mail. First class. I'll take her out in a sec. Is it better to buy you a coffee than Super Chat? Do you get to keep more? Well, right now, like, PayPal's the best thing, because we can get that straight away. And yeah, coffee and PayPal, there's less commission to pay. YouTube keeps, like, more for themselves. But I guess that favors with the algorithm. Yeah. Coffee, buy me a coffee and PayPal. That's probably the best ways to support the channel, and we do appreciate it. We do appreciate it, guys. But you know what? I mean, with the coffee, you can withdraw like once a week. And yesterday was the deadline, and I missed it. I fell asleep. It's been such a struggle recently. I was like, oh, I'm gonna withdraw, and then I missed it. So I gotta wait until September 12th to get that money. Which means we've got about fucking $30 to last for 9 days. But we did pay the rent. God damn the rent. Oh, we love your comments, Carol Johansson 2807. It's great to have you here. We appreciate any support from anybody, and we're just so thankful. More food in the case. Chicken nuggets. When did those come up? I know fried chicken came up when Donna and Charlie were trying to find something for the boys to eat alternative to lobster. Oh hell yeah, that's good. That's a good looking sandwich. Is it still up? Oh yeah, no, it was good. It was good. You know, and when he squashed it down, you know, you could just about fit it in your mouth. I have that skirt, is the line. I have that skirt. We could be sisters. We could be sisters. And you know, I know that, well, maybe I shouldn't say that I know. Maybe that's misleading. I would be happy to place a money bet on the fact that Wendy Adelson did not, never had the same skirt as the witness, as the victim advocate, Sarah Latour. And that kind of, you know, the victim advocate comes in wearing a garish skirt. And Wendy Adelson notices it because it's impossible not to. And she says, I have that skirt. And that to me is exactly the kind of manipulation Wendy Adelson does, right? It's a bit like with the interrogations that we always watch with the rapport building. We're the same. We understand each other. You know, it's like, I have that same skirt. We could be sisters. Even though looking at them side by side, Sarah Latour, Wendy Adelson, they look nothing alike at all. And saying something like, I have that skirt, is something, it's a lie, right? I'm claiming that's a lie. And it's a lie that can never be proven. Wendy knows that. It's a lie that forms a unity between them. And that's exactly the kind of tactic that Wendy does with people manipulation. I have that same skirt. Soap, 5 minutes, please. They're coming back any moment. We've got to get through these comments. Wendy to Sarah, we look like we could be sisters. I have that same skirt. Oh damn, being shot twice in the head. Well, I'm gonna go to the party tonight for a mortician. She's so pretty. Lunch is going on until 2:20. 4 minutes, Soap. 4 minutes. She might want to check her pacemaker. Who? Jackie may have taken a sleeping pill now. Let's let her rest. I wish Soap would take a sleeping pill. Here from the Sofa Squad. Hey! Oh, good to see you, Stefan. Annie? Yeah. No, many thanks to Paul for putting that video up and giving us a special mention. That was very gracious. I really appreciate it. And honestly, you know, I've been an admirer of Paul's work for probably 3 years. The first video I ever watched of Paul was way back, before he had his nice background set, and you know, he was in a different place then, I think. But he was talking about, what was the case? The case was Christopher McNabb, and I just fell in love with the guy straight away. Real funny, and to be honest, Paul was one of the first guys that I watched that got me starting to think about, hey, maybe I should have a YouTube channel talking about all these crimes and stuff. So it was really cool to get a message from you guys, and a very polite message, and say, hey, do you mind if we use the video? Of course, no problem. Really appreciate the message, and I haven't been able to watch the video he put out yet because we've been live all day, but looking forward to watching that later. And please pass along my kindest regards. Yeah, Carol loves Paul too. He's the sweetest guy. Welcome, Stephanie. You will enjoy it here. Oh, I don't know. I mean, this little channel over here, I mean, Paul's so polished in his channel. I mean, we could, you know, it's a nice standard. It's a nice target to get to. I think we should maybe try and switch up the format a little bit here and do something a little bit more professional. It's okay, Frank. We just wait while you take soap out. We're cool, I promise. Yeah, I'm just gonna well, maybe I should take the burger picture down. As nice as it is, god damn. I wish I had one of those right now. Yeah, please hit the like button, subscribe. Good advice, good advice. Lecherous, like a creepy, grabby type guy. Can you imagine? Not a sandwich for a little mouth guy. Not like that witness yesterday. Let's bring him up. The guy with a mouth that was 5 times too small for his head. Where was that guy? What's up with that? Where is it? Where's that picture? I can't find it. There's the emu. Maybe we should put up the judge. Put up the judge. There we go. As far as my own merchandise, this is the t-shirt I really want. The new Florida seal with Judge Everett front and center. In cake we trust. That's what we're all about. Charlie got chicken nuggets when he was transported. Okay, I forgot all about that, sure. Alright, well if we're cooking chicken nuggets, we're gonna do some real good ones. Old-fashioned bread pudding. Well, that sounds great, but was that mentioned in the show? In the show? The case? So, give me a minute. Thanks so much, Carol Johansson 2807. Hot buffalo wings. Teresa. We only want to cover food items that were like actually, we want to make an Adelson case cookbook, okay? And all of the food that is mentioned within the case, that's what we're going to be making and providing recipes for and so on. Have hot buffalo wings been mentioned? I get the feeling you're just telling us what you want to eat, which is great, but you know, what about the salad the FBI agent had? Yeah. FBI salad. That might be a good one. Agent salad. We already had Agent Google today. What was it? Chief Google. It's called ingratiation. When Wendy tries ingratiation. I'm not familiar with that word. It's called ingratiation when Wendy tries to say that she and Sarah are so similar. She is suggesting that I couldn't be something bad because you wouldn't. I couldn't do something bad because you wouldn't, and we're the same. Yeah. Well, yeah, I mean, I think it might be a little bit more general than that. I think it's like we're comfortable together. We're not adversaries here. We're not against each other. You know, it's broad, right? It's all encompassing. It's not, I don't think it's quite so specific as that. Obviously that would be included, but yeah. It's a very broad thing. I have the same skirt. But I would bet good money that Wendy does that any opportunity she can in any area of her life, not just when she's trying to beat a murder rap, right? They have chicken nuggets in jail. Really? Maybe you should change that in cake. Maybe you should change that in cake with trust in chocolate thunder. Oh, I love that. That's great. Trust in chocolate thunder. I would have gone with the breast. I would have gone with the breast. Large order of hot French fries. Piri piri fries. Red velvet cake, of course. Now, I've never been much of a baker. I can cook pretty well. But, yeah, I mean, we can do a cake. But I think my oven here doesn't really work. It's like, I don't think the temperature gauge adjusts. It's just on max, whatever temperature you put, which is a bit annoying. And not great for cooking cakes. But maybe someday, when we move out of this hellhole. Black Eagle, you gotta send us some Maine lobsters for the cookbook. Donna Brown bagging lunch with her homies. Ah, this dog won't leave me alone. But hey, you know, the defense never seen Judge Everett so heated in his admonishments, in his statements to the defense, to the witnesses, right? Never seen that. Didn't see that at all in the last trial. He was very, very lenient, kind with Daniel Rashbaum in the trial of Charlie Adelson. Gave a lot of leeway. And I thought that was his general style, but in this trial, he's shown us that he's got teeth as well, right? We all knew it. We all know it. Hey, should we watch the beginning of Paul's video where he mentions me? I still get a buzz out of it. Like, hey, look, someone real acknowledged me. I do exist.
Prosecutors would say that this murder was fueled by a bitter, bitter divorce.
She says, you know, Charlie.
Charlie did actually look into having him killed last summer.
You would have thought the tea that came out in this interview would have put all the Adelsons behind bars, but hello, a couple of them are still walking.
By the way, if anybody doesn't know this channel, where the hell have you been? And go and subscribe because it's great.
Free. Let's talk about this salacious interview in today's video.
Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey, hey.
Now hold on everybody, let's do a quick sofa sidebar now. Keep in mind, ain't no cop, ain't no doctor, ain't no lawyer, ain't no therapist, ain't none of that fancy credentialed stuff, okay? Now keep in mind also, I'm just giving my opinions on very public information, so do your own research.
Man, I wish I had a sexy North Carolina accent too. You know, maybe that's it. Maybe that's what we need. Okay, I need a voice coach. Is any viewer from North Carolina? Because I got to learn all about it, right?
Research, come to your own opinions and drop them off in the comment section. And while you're down there, if you do like what you see here at the Sofa Squad, drop a little like, drop a little comment, drop a little share. It helps the channel out immensely. Now let's get edition. Hello Sofa Squad and welcome back to the sofa. We got a sofa. We got a Paul. If you're new to the channel, my name is Paul, and if you're not new to the channel, my name's still Paul. Okay. So today we're going to be talking about a very notorious interview that took place. This is between Jeff Lacoste, and police interviewers. Now before we get into the interview, I want to give a shout out to the channel True Crime Metrix. They were nice enough to let me use this video to do this video, to use their video of the interview to do my video, if that makes sense. But check them out. They have a great channel. They got a lot of coverage and a lot of great information and content on there. So very much.
Great channel, a lot of coverage, a lot of content, a lot of information. Damn hell straight.
Thank you, True Crime Metrix. And there you go. So if you're brand new to any of this, let's do a very quick 60-second overview of who the Adelsons are and how we have arrived at today's video. So 2014, Florida State law professor Dan Markel, he was gunned down in the driveway of his Tallahassee home. Now, the prosecutors would say that this murder was fueled by a bitter, bitter divorce and custody battle with his ex-wife, Wendy Adelson. So over the years, investigators did uncover a murder for hire plot that tied members of Wendy's family to the crime. We're talking hitmen.
Now, that's about all I've seen, and that's about all I'm going to show right here. The channel is Reporting Live from My Sofa. I'm sure many of you already know it and subscribe. If you don't, go and do it now. And I'm looking forward to watching it later. But, you know, go and give him the views. Go and give him the views. Whoa. Yeah, no, when I saw this come out, it had like 60 views and now already 7,000. That's going to go way up. So it should be pretty good exposure for us. That's real nice. We do appreciate it, Paul. Yeah, so, yeah. What are we going to do now? A couple of minutes. We're already 11 minutes late. God damn it. Timekeeping in this trial has been terrible. Everything is late, everything is delayed. And at least in the defense's case. Amy says, Everett, there has been time pre-trial to prepare for this moment. There's been time during trial. Oh, my accent is the best? I don't even know what my accent is. Oh, okay. So Judge Everett said that he will give 5 minutes to Donna to decide whether she wants to testify. I can't believe I'm gonna miss goddamn Sarah Latour. I really want to see that. PB&J for Donna. Ah, I would murder a PB&J right now. George's dad, Bill, played QB for the Florida State Seminoles from 76 to 79. Greatness was automatic. Yep, that's true. A born leader. Joel said it was a snooze fest with jury, but everyone was at attention when Georgia got up there, and a couple jurors who've shown no expression were stunned. Yeah, she put on a show. I don't think they're back yet. We're right on the button with the live. Oh. And Zellman tried to pull another stunt, saying he was hearing things over his right shoulder and things in the gallery were happening that were influencing the jury. Everett wasn't having it. What is this? This is from... Where's this information coming from? Joel. Where is he getting it? They're talking in the room, but they're on mute, I guess. I gotta take Soap out. I'm gonna be back. I'm just gonna take her out for a piss, I guess. I'll be back. Okay, that's all good. We're set. I'll see you in 10 minutes. Good luck.
You can bring in the jury. Everyone can be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state? Defense 50 is admitted.
Thank you. At this point in time, the defense would call Marisol Descalzo.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated.
Thank you.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled Descalzo.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
Okay. And I want to direct your attention specific to October, the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yes. Can you tell us what those were?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting is putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor.
Nothing further, Your Honor?
Cross-examination.
Yes, sir. Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended, is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to, I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay, and you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was before, definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overruled. The witness has opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight.
As her attorney,
Okay.
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second. Specifically, though, about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor. Mr. Scalzo, prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
No, Your Honor. I believe she might be able to get the early flight this evening.
You are released. Please call your next witness.
Just a moment, Your Honor. Defense would call Sarah Newhouse.
Please come up to the witness stand. Raise your right hand now. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendy Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendy Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendy Adelson called her mother?
I did.
And I'm going to show you.
Were you present when Wendy Adelson had to call her mother at the end of that interview? And did my client, Donna Adelson, sound very surprised that Professor Markel had been shot? So it obviously wasn't her, right?
What is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay, and is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendy Adelson called her mother?
It is.
Okay. When Wendy Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Okay. Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear.
It's amazing to me that they are using Donna's badly acted, community theater level. Less than community theater level. Community theater can be very good. It was like the performance of a high school drama student that doesn't want to be there. They're just going through the motions because they're trying to bang some chick or the other way around. It's like it was like a non-drama student's version of an act, right? They're using that as a reason to say to the jury. So she sounded really upset, didn't she, on that call? She sounded mortified. Hey, Jack's Cracks, how you doing?
Other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
At this point in time, I'd move into evidence Defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that, objection.
A lot of qualifications.
Well, there's just...
Members of the jury, we're going to take a brief break. The bailiff will take it to the jury room.
Look at that big old innocent ear on the side of her head. I think she should have got a prison tattoo on her ear that said innocent all down the side. God knows she has the space.
You can be seated. If anyone needs to stretch their legs or use the restroom, please do it now.
What is the deal with the restroom? I know that there's whenever there's a number of people together, I guess it's your chances go up that somebody needs to use the restroom. But why can't everybody just prepare for the day? You know? It's all the water people drink these days. And I'm all for drinking water, but not in court. Never in court. Don't sit in court all day drinking water. Inevitably, you will need a bathroom break. And, you know, as we've seen, that has tremendous potential to interrupt proceedings, to delay proceedings. How was that sandwich today, Harv? Did you get a pickle? Anybody who didn't see our show a couple of days ago, we got a picture of Harvey Adelson ordering lunch at the Metro Deli with a pickle, a huge pickle that comes on the side of your tray. Sandwich comes in a little basket. Side pickle. Why not? We all know he's been there every day this week.
It includes Wendy Adelson saying this is the worst day of my life before the call connects, and then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments. I'm fine. I understand they don't tend to publish it right now, so subject to those objections, no objection to the exhibit once those things are removed.
As I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. You can bring back to the jurors.
Well, my mom sounded really surprised, so that's a relief. So it's not her.
Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendy Adelson, her daughter, presumably does know.
Correct.
And do you remember Wendy Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the
Please sit down. That's the hearsay. Sustained.
No further questions.
Redirect.
Your Honor, we'll just strike the question from Ms. Kaplan.
Members of the jury, you are to disregard the last question of the prosecutor is to be struck from the record. You may step down. Will the witness be recalled?
Disregard the last question. I think the cat is out of the bag, right?
No, Your Honor.
As to your exhibit, do you wish to publish or just leave in evidence?
Not at this time, Your Honor. I do need.
Doesn't Sarah look like just, you know, a nice, caring person?
As to your exhibit, do you wish to publish or just leave it evidence?
Which are probably really good aspects to have for a victim advocate, right? And she had the misfortune of meeting the devil herself.
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that it removes the two references.
Donna's demeanor in this whole thing has been quite hilarious. It's just like she keeps like glancing over. You can tell she's constantly processing everything that's going on, you know, listening intently, glaring, glancing, everything's going on for Donna. Desperately trying to find a way to make herself believe that this is going well.
Just take a few minutes.
Well, the jury will have a brief break. They'll take the jury room.
Oh my God. Brief break again. It's like all the jury are doing are going back and forth.
Everyone can be seated. Please make all necessary redactions and changes at this time.
So, who's next? They said, it was Sarah Latour and... They're on mute, by the way, we can't hear. Why are they on mute?
If there are no other witnesses for the defense, it is time for the decision to be made.
Whoa, okay, here we go.
I can tell the court that co-counsel and my client are deep in conversation. Sorry,
I
yes.
am capable of seeing that, Mr. Zell. No narration is needed.
Feels like she's not going to testify in her defense. This is the moment, Amy. This is the moment. They've got no other witnesses, right? It's either testify or end the case here. She's got to get up there.
Mrs. Cappleman wants the defense rest as the state intending to place or put on any rebuttal case.
I think not. If they rest without calling any further witnesses, that could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise.
Whoa. Fucking hell, this is intense.
On your oath earlier this afternoon, Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared
to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Whoa.
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point.
Fucking hell, this is intense, isn't it? I have never seen anything like that. And I don't know why I didn't predict that. That was obvious that she would try and seek out some more time to make the decision. Do you think she's going to fake a heart attack or something? One thing's for sure, Judge Everett is over this completely. I know. Look at Amy. She's all crazy now. She's forgot her troubles. She's just like, Donna! Oh. Wow, you know, the intensity. It's like waiting for the lottery numbers. You've got 4 lotto numbers and you're waiting for the next one. All right, I mean, what are we thinking? I think she's going to go for it. I think she's got stage fright, right? She's always been planning to go for it. And it's intimidating. But man, you know, if it were me in this situation, and the state had made their case, and the defense had made their case, if that's it, and both parties conclude, and it goes to closing argument, it's a done deal, right? If she testifies, she's got one more chance. It could not possibly be worse than it is for her right now. No juror is on the fence. She's not going to upset the fence. The jury surely is decided at this point. If she testifies, she's got one more chance to get it over the line, to push some jurors off that fence onto her side. I wish we had cameras on them, because I'm sure she's glancing back at Harvey, who will either shake his head or nod. You gotta go. Go. Your Honor, can I speak to my client? What exactly are we going to achieve by that we have not been able to do pre-trial, during trial, in the long recess yesterday, or in the lunch break? Judge Everett is sick of this, isn't he? Come on, David Anderson Kirk. I think she will testify, David says. Brian! It's in her best interest to stay silent, in my opinion. Well, I don't know. It would be if her defense had put on any case whatsoever, but they didn't. She's got to get up there.
Can be seated. Mrs. Elman, Ms. Fulford, Mrs. Adelson, the extra time that you've been provided, that has come.
I don't think that was 5 minutes.
We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify. What is your decision concerning these two rights?
Go for contempt.
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
What time is it in Tallahassee? It's only 3:15, right? So, are we going to have closing argument today? Surely not. Oh, you're not looking confident now, are you, Donna? At this stage, I do not want to testify. Kappelman must be livid. I'm sure she wanted to slap her all down the street and through the courts.
There is one matter, Judge, that I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors, or we can decide the language now if you find that more acceptable. It's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
Wow, we're really wrapping up. Preliminary copy of the jury instructions was sent to everybody this afternoon. No testimony from Donna. The defense has closed their case. No rebuttal from the state, and one stipulation about what was her name? Bird, the black lady that was a jailhouse informant, was not on the defense list. I mean, what does that matter? I don't know.
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. We'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Your Honor, can counsel have a moment to confer concerning whether or not we are going to rest at this point?
Do you have another witness to call?
That's what we need to discuss, Your Honor.
We've done a lot of conferring. Please quickly come to a decision as to whether there is another witness, in fact, for the defense.
They're going to get their heads together. Who can we call? You know what? They should call Harvey up here. Why isn't that being done? Why haven't the defense called Harvey Adelson? Credibility, co-conspirator. They've done nothing. The whole case in chief from the defense was nothing. They only addressed the issues that happened post. I'm stunned. I'm stunned that after close to 2 years, okay, there was some this defense team's only been on it since what? Just shy of a year. But they've had plenty of time. We were robbed. We were robbed. We've been waiting for this for years. We wanted to see Donna up there. We wanted to see what she'd say. We wanted to see the cross. We wanted to see Georgia tear her ass up. What is going on in these comments? I haven't even read any comments. Nicole. Oh, so she's not testifying. I just got home. Yeah. Oh my God, Nicole, you wouldn't believe today. It's been a crazy day. Great. Well, mostly a crazy day of nothing, but that in itself has been crazy, if you get what I'm saying. And now Donna's not going to testify? They're resting? Or they're trying to decide whether they're resting. They're searching their brains for one more witness to testify. I think they should say, Your Honor, the defense calls Harvey Adelson to the stand. That'll be better than nothing, right? No Charlie, no Harvey, no Donna, nothing.
Is there another witness to be called?
Your Honor, we are going to be tendering 2 exhibits to the court to introduce. I believe that both qualified or hearsay exceptions. The state's indicated that that they're objecting. If I could just have a moment.
So I just did a Google search on can a defendant go back on their decision not to testify? And the answer is yes, a defendant can change their mind and decide to testify after initially opting not to. Although the decision should be made in consultation with their attorney and the judge, the right to testify or to remain silent ultimately belongs to the defendant, not the lawyer. The defendant must actively express this desire to the court at an appropriate time, and the judge will allow it, provided there is enough time for the prosecution to prepare for cross-examination. She might sleep on it. She might sleep on it and find her fucking balls tomorrow, you know? It could happen. And if that did happen, I believe it would be granted. It's a heavy penalty, so the court's always, you know, give a little bit more breathing space to those decisions. I'm sure it's something that occurs now and again. And she did word it like at this time.
Concerning the items, we do need to move on so a ruling can be made.
She worded it at this time, right? And I believe that she was advised to do that by her defense counsel in the colloquy that they just had, right? They said, listen, if you aren't going to testify now, you're going to have to say, at this time, I do not wish to testify. So it just leaves that door open a little bit, right? The wording, and that's lawyer wording. That wasn't by accident. That didn't come from her naturally. That came from the defense counsel advising her to say it like that. I don't think they need to do a rebuttal at this stage. What would they be rebutting? They didn't have a case. You know? They didn't speak to any of the implications. Amy should give an impact statement. Amy right now is probably standing on her desk.
I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar. That is, I believe it's states 51. No.
I really don't think they're going for Harvey. Music by Brian. Anything Harvey says will be used against him. Well, wouldn't he be able to have the immunity, the same immunity as Wendy if he was called by the state? Oh, well, okay, no. He would be called by the defense, obviously, and that doesn't confer any immunity. All right, well, there is that. But he's 81. I really just don't think they're going to bother. David Anderson says they had nothing to work with. Well, I think they could have put a better case with what they had to work with, and I'm surprised that their focus was all on the post events.
Cattleman, concerning these items, was the state's argument?
The state's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar, it's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents. The state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that, there are a ton of pages going back to January 9th of 2023 where my client lists those very same items to get prices to sell, to sell, to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes
Who was
of...
going to lay the foundation concerning the items that you wish to admit?
Foundation's already been laid by the state, Your Honor. It was seized
I
by...
believe as the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted, not that she was...
Hold on, these are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
All we're seeking to admit are the pages.
Is she going to turn around in the next 3 minutes and just say, I want to testify? I mean, fucking anything could happen, right? She could come back tomorrow morning and say, I want to testify in my defense. And that would probably be within the rules and granted. We don't know. Man, I'm not going to sleep at all tonight.
Pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I've prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. These are just the pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research, but again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I'll reserve for now. Depending on the court's ruling, you may argue it in closing. It's the same argument as the 2014 calendar.
Just a moment.
Man, I've never seen Judge Everett this pissed. He is like, he's really good at keeping cool at the same time as letting you know he's fuming, right? He's very talented at that.
Excuse me, Your Honor. The argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband, and the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you might already made?
The only entry from the 14 planner that was admitted, has been admitted so far in this trial, is the page that shows
License plate.
The license plate
the
number.
license plate number.
Yeah.
And so I don't see how birthday party planning adds to the completeness of possessing the license plate numbers. I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been.
They're trying to get the birthday planning in. Oh, God.
Identified at all.
Your Honor, as far as the rule of completeness, we need to submit pages 79 through 85 that show that Donna Adelson had a toenail appointment on June 5th of 2014. It's like, what? This is irrelevant.
That page was identified. 23 planner was identified as by a witness as it being seized from the residence.
I will reserve ruling as the 2014 planner as well. Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor, and for record, what I've done is I've marked the 2013 excerpts as defense, the 2023, sorry, as defense 51, and the 2014
I forget what comes first. Is it closing arguments and then jury instructions, or the other way around?
as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please bring in the jurors.
Has made I want to check the redactions on this video.
I believe this is just being admitted without being published, correct?
That's correct.
Yep.
Thank you.
Jurors are fine to come in.
All right, you're entering the courtroom.
Donna wrote everyone's script but her own. That's clever. Top marks, kosher style.
Everyone can be seated. Defense may call its next witness.
Also very good, Christina. Her case was weak, but not as weak as her counsel.
Your Honor, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties, and from there tomorrow you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good evening.
Yeah. Zellman's gonna be shuffling papers from 9 o'clock, so we'll be started at about 9:15.
Everyone can be seated. Please open your copies of the jury instructions. My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
Can we have a moment, Your Honor?
No, sir.
3.2, Statement of the Charge. Any?
Amy, I believe she can still change her mind. I mean, if we can have any faith in AI, it says, yes, a defendant can change their mind and decide to testify after initially opting not to. Although this decision should be made in consultation with their attorney and the judge, the right to testify or to remain silent ultimately belongs to the defendant, not the lawyer. The defendant must actively express their desire to the court at an appropriate time, and the judge will allow it, provided there is enough time for the prosecution to prepare for cross-examination. So I believe up and until closing argument, from at least if we're to take this as the truth, that she could come back tomorrow and say, I've decided to testify, but it's probably not very likely. I don't know. It was just that wording in her statement of, at this time, I do not want to testify. That sounds like it was suggested to her by her lawyer to at least sow the seed that it was not unequivocal. Right? It would be one hell of a coincidence if that was said by accident and not by the instruction and advice of her counsel.
Requests or changes?
Nothing, sir. Your Honor, the only request that I would make is that the name of my client and the names of the charges do not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note.
Yeah, Amy, ask your boss. Amy, ask your boss.
Moving on to 7.1, Introduction to Homicide. This is a mandatory instruction in all murder cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
Daphne says, Amy, you need to include this factor in your question to your boss. Daphne 35 says, I think that she would have, sorry, I cannot read. I think that she would have to have changed her mind before the defense rested. The case is over now. I don't know the answer to that. I suspect that due to it being such a severe crime, penalty, and all the rest of it, that there's a little bit of breathing space, but I don't know. Amy, please include that factor to your boss and let your boss know that the case has rested. Can the defendant revoke their decision to not testify and choose to testify after the state has rested? What is the cut-off point? That's what we want to know from a lawyer.
As to the next paragraph concerning lesser includeds, is the defense asking for all Category 1 lesser includeds?
Lesser included. Any of the lesser includeds would be a life sentence to Donna. You know? Doesn't fucking matter. So by that rationale, it would be best not to have lesser includeds, right? Not to give the jury that option. Because sometimes I think a jury will use the lesser includeds to kind of do a middle ground. If it's a case where they can't agree, they'll say, oh, we can't get you to do lesser includeds for first degree murder. Oh, sorry, we can't get you to do vote for a guilty verdict for first degree murder. Well, we'll settle on second degree murder. And they kind of, you know, like, it's almost like a negotiating thing sometimes with jury. I think it's stronger not to have lesser includeds for Donna.
Confirming my recommendation being approved by our client, Your Honor. Your Honor, the defense would request the manslaughter lesser.
As to the second degree lesser, are you requesting that as well as Category 1?
With the although it's a Category 1, the lesser still carries the same penalty, so we are not requesting second degree.
Is the state requesting second degree as a Category 1 lesser?
Yes, sir. Yes, sir. We'd be requesting all lessers.
Well, all Category 1 lessers will be given. Second paragraph will read in the introduction, first degree murder includes the lesser crimes of second degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. I believe the indictment refers to the victim as Daniel Markell. Does either party have a preference?
To conform to the indictment, we would request his full name, Your Honor.
Acceptable.
If you find Daniel Markell was killed by Donna Adelson, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force.
Shit. Does everybody know this Where is it? This one. Does everybody know this train in Lisbon? Well, it's the train that goes up steep hills, and it just crashed, and there's 15 people dead. Fuck, you know? Yeah, fuck. You heard it here.
The definition of justifiable homicide and excusable homicide is either party seeking these. Not entirely certain we have any evidence in the record that would support giving them, but as either party requested.
Just a moment, Your Honor.
Mr. Evans, Ms. Koppelman.
No objection removed.
The definitions of justifiable and excusable homicide will be removed. As to any other degrees, I believe the evidence remains the evidence. I do not find where there is a basis to give either set of instructions as to the lessers. The final paragraph of the introduction will read, I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder or any lesser included crime.
All right, Christina, there's your poll. How long will jury deliberations take? Options: 3 hours, most of the day, or multiple days. Let's see what we get.
As to count one, the state is only proceeding on the premeditated theory. Is that correct?
Yes, sir.
Any reference to felony murder will be removed.
So, I mean, I know that most people are going to know this, but just in case anyone is watching that doesn't know, felony murder is like if Donna Adelson was planning to do something to Markel, Professor Markel, like rough him up, beat him up, but he ended up getting murdered by the efforts that she was involved in, even though her efforts were not the murder. But if that was a subsequent thing that happened from something that she did plan that wasn't murder, she would be guilty of felony murder. Just in case anyone didn't know that. I mean, someone else can probably explain it better than me, but I'm the one that's here.
The elements of first-degree premeditated murder. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel.
Veronica's parents were just on that train. I mean, that's the most tourist photo in Lisbon. That's on all of the, I think it's the most famous train in all of Lisbon, definitely. And yeah, a lot of people ride that. I've been on it. It's fun. I mean, not when it crashes and everyone dies. Yeah. Thoughts with the victims. Thoughts with the victims.
No.
Just the stylistic issues that we raised previously.
Very well. Instead of caps, they will be in upper lowercase. Moving on to the definitions. The definition of an act will be given. Killing with premeditation, that will be given. The question of premeditation, that will be given. The portion that will be omitted, give only if there's evidence the defendant acted in the heat of passion on legally adequate provocation, that will be removed.
I bet Charlie refused to testify unless he got 2 Baconators with jumbo fries and a Frosty from Wendy's.
Right, instruction 3.4. This deals with the lessers. Is there any objection or request other than the stylistic issue previously raised?
No, sir.
No, Your Honor.
Oh, Amy's asked her boss. Amy says, I'm back. My boss said that because testifying is such a major constitutional right, the judge may allow her to testify in the morning, but she doesn't see how her planner could be let in without her. Do I have a good instinct for this or what? That's exactly what I said. Because testifying is such a major constitutional right, and obviously coupled with the severity of the crime, the crime and punishment, right? Yeah. Who's got a good instinct? Metrix. We ask a professional, the professional agrees. She also told me that I need to go to law school. I'd love to. I'd love to do a law degree. I would love to become a member of the bar in the United States. I mean, can you do that as a non-citizen? Because that's the system that I know the most about. And I reckon I could do it. I think I could do it. I'd love to try.
All right, 7.4, second-degree murder.
Not to practice, just to achieve it, That'd be really cool.
Introduction to homicide will be given. This portion of the instruction will be removed. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, Daniel Markell is dead. Element...
Yeah, I think we've got that one sorted.
2, the death was caused by the criminal act of Donna Adelson. Element 3, there was an unlawful killing of Daniel Markell by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life.
San Sebastian, huh? That's a nice town. With tough people, man. I think it's because of all the weather they have around there. Yeah, I like San Sebastian.
As to the definitions, I believe act is repeated. Is there any objection to this stating an act has been previously defined above?
I don't have a legal objection to that, Your Honor.
Mr. Evans?
No objection.
Amy's boss says that Donna sounds like a client who is in control. And I said that, and Amy said that's exactly what she is. That's interesting for your boss to make that just on what you said about her refusing to testify, but maybe leaving that open. That's interesting that your boss should pick up on that. But I guess if you're in the trade, they know those kinds of things. Is that a public defender, Amy? Is that what it is? Your boss?
The second definition, an act is eminently dangerous to another and demonstrating a depraved mind. That must be given. In order to convict of second-degree murder, it's not necessary for the...
Kosher Style says, Nicole probably won't miss closings because Selman needs till noon to shuffle papers, confer with his client, ask for breaks, argue with Everett, then subsequently get chewed out by Everett, so you're good. Perfect summary, Kosher Style. Good job.
State to prove the defendant had an intent to cause death. That will be given. Give only if there's evidence the defendant acted in heat of passion on legally adequate provocation. That will be removed. The next lesser, 7.7 manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, Daniel Markel is dead.
We got it. We got it.
As to element 2, which theory is the state proceeding on?
They're not. Let's think about that. In what possibility would it be manslaughter? If she'd have hired gun thugs to just go up there and scare him or threaten him, and he got killed, that would be felony murder, not manslaughter. So, in what situation could it possibly be manslaughter? I really don't know. Can anyone tell me? In what, forget about reality, just reshape reality and tell me what happened with Dan Markel, and you can make anything up, just completely rewrite reality if you need to. In what set of circumstances could Donna Adelson be logically charged with the lesser included of manslaughter? How would that work? Like, manslaughter is essentially by accident, right? I mean, in its most dumbed down form, in a situation where someone was accused of murdering someone by running them over with their car, and the state was contending that they did that intentionally with purpose and intent to kill, and the defense argued that it was an accident, but the jury thought that the defendant was drunk at the time, that would be vehicular manslaughter, right? I mean, that I guess it's more than an accident. It's an accident born of some fault of the defendant, right? That's what it is. Like if it were a vehicle crash, it would be if they were drunk or if they were speeding or something like that. But how would it apply here? That's what I don't get. In what possible scenario would this whole situation come down to Donna Adelson being found guilty of the lesser included of manslaughter?
Well, A and B will be split by and for. Donna Adelson intentionally committed an act or acts that caused the death of Daniel Markel, or Donna Adelson intentionally procured an act that caused the death of Daniel Markel.
Daphne, you do fine. You do fine.
Right. Concerning the State versus Spencer italic, that will be removed.
And my understanding, Your Honor, is given the fact that the defense has not.
Tara Kawas is surely a U.S. citizen. You know, she's Jamaican origin.
Requested that instruction, has agreed there's no legal basis to give the instruction. There is a concession that the homicide of Daniel Markel was not excusable or justified.
Zellman, do you need to be heard concerning the concession that it's not excusable or justified?
Not in the facts of this case, Your Honor.
Yeah, right.
And defendant agree with that concession.
Very well. Mrs. Adelson, do you understand what is being omitted from the jury instructions?
Just 1 second, Judge.
Go ahead.
Non-cooperative answer coming.
Okay, Judge.
Mrs. Adelson, do you understand what is being omitted concerning whether this homicide was justifiable or excusable?
I do.
As to that concession, do you need anything else that you need to discuss with your attorneys?
The consensus is, Nicole, that Wendy is very, that they're coming. And they're coming quick. A lot quicker than we thought, because we didn't think trial would be over until next week. What the fuck? 2 days. 2 days of absolute nonsensical bullshit witnesses in the defense case in chief. That's it. No testimony from Donna, apparently. We'll wait and see till tomorrow.
I said yes.
Please discuss it with them now.
Thank you.
Man, she's gonna go into some depression, isn't she? Don't forget, after they convict her, if that's what's happening, which very likely is, she's going to be placed onto suicide watch. She's going to be in that room that Charlie Adelson was in with fucking, what was it? Piss on the floor, blood on the walls, and shit on the ceiling for 4 days. While Chief Mack is trying to find the number of that witness. Trying to get himself some sugar. I think it would be really cool, Kosher Style. Kosher Style says she's going to change her mind, I bet, and testify like she said in her emails. Show these fuckers who's in charge. They haven't beaten the Adelsons yet, when in fact they've beat 25% of them. I think that could happen. I think I'm I think I'm erring on the side of probably not, but that's probably just because it would be so unusual. I've never seen that happen before. I've never seen a defendant refuse to testify and then come back and change their mind. But apparently, that would be allowed. And Donna's attorneys know that, so Donna knows that. So she's gonna be sleeping on it tonight. And she might find some fucking balls tomorrow. Let's hope that she does. That'll be a great day. I mean, we're gonna have a great day either way tomorrow. It's either gonna be closings, which we're all looking forward to, right? Or we're gonna see Donna testify. Either way, great day. Do not miss it on True Crime Metrix. Interesting comment, Christina. Christina says, I could see Donna thinking that not testifying under duress might be appealable. You know, I could see that for a witness that was 45 years old. At 75, it's break or bust, right? I mean, an appeal, even in the slim chance that that was something that was allowed and successful, how long would it take? Multiple years. She'd file within 30 days. Let's say, I mean, the bare minimum would be 2 years, I think. Do we hear of appeals that happen less than 2 years? Do we hear of appeals that are heard by someone that can grant relief less than 2 years after conviction? I don't think so. Not one that I remember. You know, it's break or bust for Donna. And I'm surprised. I'm surprised that she's chosen not to testify, especially with the totally inadequate case that her defense counsel have laid on. Nothing. Top boss of 2 counties.
Ms. Adelson, you understand the concession that is being made as to justifiable and excusable homicide.
I understand that.
You are giving your consent to this.
I am.
Let's move on at this point.
I just busted into her office like a psycho. I can see it. I can totally see that.
The paragraph that states every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. I believe the period needs to go there because there will not be any discussion of justifiable or excusable homicide. Does either party wish to be heard?
We concur, Your Honor.
In order to convict of manslaughter by act, that paragraph will be given. The last portion. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only
100% that Donna Adelson would have asked the question to her attorneys, if I say no, can I change my mind tomorrow? And as far as what we've learnt from AI, as far as what we've learnt from Amy's boss, who is the lead chief top lead public defendant in 2 counties in Maryland. Apparently that is on the card, so we can assume that her counsel would have informed her that yes, you can change your mind tomorrow. So yeah, it does seem that. And Donna's wording at this time, I do not wish to testify, blah blah. She's given herself that time, right? It's not for the judge to inform her, well, you can make a decision tomorrow. But there is still a way to make that happen. The defense counsel know that. And now Donna knows that. And that's what she's done. So she will be thinking about it tonight. That'll be all she's thinking about tonight. And we won't know until tomorrow her final decision.
An intent to commit an act that was not merely negligent and which caused death. The justifiable and excusable portion of the sentence would be removed. Does either party wish to be heard?
No.
No, Your Honor.
The definition of procure will be given, and all other references to culpable negligence will be removed. Moving on to 3.5 sub A, principles. The 2 elements are static. As to the portion below that is italicized, or any of the italicized portion.
Amy, I'd be curious to know if there is a cutoff point, what the cutoff point is. Like if closing arguments go out before Donna decides to testify, would that be the cutoff point? Sorry, closing arguments have already gone out. I think it probably would. Or would the state be granted the opportunity to make another closing argument? That'd be weird. There has to be a point where it's a no-go in Wendy's terminology. Your swimming idea is a no-go.
Is being requested.
The appeal's going to take forever and she's 75. Yeah, exactly. That's no good. I mean, she's going to die in prison. That's the thing, right? All we're really doing here is witnessing the process of a defendant realizing slowly that they will not be getting out and they'll be dying in prison. That really seems all it is. All roads lead to Donna dying in prison. You know? As far as an appeal, it is insanely unlikely. You know, if the defendant was 25 or even 45, something like that, and they had 30, 40, 50 years to work the system, maybe they could get out one day on an appeal. But I mean, but at 75, what have you got to in your favor? Not much. Not much. The best thing she had in her favor was that age and displaying that age to the jury, but it didn't exactly go well for her when they did that little dress rehearsal. I think it was back in March when Donna got up on the stand and spoke about her fucking ear canals and pasta and potatoes, spaghetti and potatoes, you know. That wasn't a good look in itself. And now we're here. Anyway.
I believe as to the first paragraph where it says attempted homicide cases.
We're not at that, just for the completed offense.
Say that one more time, Mr. Evans.
We're not asking for the attempt, we're just asking for the
Correct.
completed offenses.
I believe that instruction must be given for first-degree premeditated murder, and all references to attempts of any other sort will be removed. The state must prove the defendant intended that the killing of Daniel Markell occur. As to the paragraph that concerns second-degree murder, felony murder, or other attempts, I believe this paragraph needs to be given as it relates to the lesser as well. For second-degree murder,
Metrix squashed balls. Well, there's a good T-shirt if ever I saw one. Or coffee mug. Check out the merch store in the description. We don't have that one yet, but we fucking should.
it is not necessary for the state to prove the defendant intended the death of Daniel Markell.
Your Honor, I think under that, the manslaughter instruction, or manslaughter needs to be included.
JC Ryder says, "Damn you, Florida, you always have such stupid rules." I think it's the heat and those bugs. The heat and the bugs and the gators. That's what gets to them down there. And they make up all these rules.
Concerning whether an intent was necessary for manslaughter as well, Mr. Evans.
You have to intend the act, but you don't have to intend to kill.
As to that inclusion within the principal instruction, does the defense wish to be heard?
Just a moment, Your Honor.
It's not included in the standard instruction, no.
Can I have some time to research that to make sure that I'm not inviting error?
That's fine.
And Mrs. Dillon, if you can contact me on that, Judge, and I'll let you know hopefully later this evening.
Yeah.
Right. If given to the jury as requested by the state, it would essentially mirror what it states as the second-degree murder. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markell. No weapon enhancement is being sought by the state. I believe that paragraph needs to be removed entirely. Does either party wish to be heard concerning those?
Are you asked?
For cases where the criminal statute includes a higher degree because of a firearm.
Yes, sir. I would skew down to the principles already connected to that. So I ask yes or no. There's no evidence that.
Christina says, "In my opinion, she is only thinking of not testifying so that the world does not witness Georgia tear her limb from limb. She is preserving her last shred of pride, hubris, and cowardice," right? That's the act of a coward. A hubris coward.
The defendant in this case actually possessed a firearm, so no, we're not requesting it.
That will be removed. .5 sub B, principles when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit
David Anderson Kirk is back. Did I miss anything? Not really, though we have been discussing a few things. How's the hair? Is it? Did you ask for the Georgia Kappelman or the Sarah Dugan?
A crime, the defendant is a principal and must be treated as if she had done all things the person who was promised or received the money did if the state proved beyond a reasonable doubt. And then elements 1, 2, and 3 are to be given.
It has to be
As to
before
the
closing
bracketed
arguments.
portion of element 3.
Yeah, I thought so.
The offense that the state is asking for to read in element 3, would this be first degree murder?
I'm sorry, Your Honor. Can you say it again?
Element 3, the bracketed portion, it says crime or attempt. The crime that the state is requesting, is that first degree murder?
Yes, sir, but I don't believe that, I don't think it asserts crime. I think you just leave the crime was committed by another person.
Christina says, Jackie came up with the idea of waiting overnight and then deciding to testify. It's got her fingerprints all over it. I agree, but I mean, surely it would have been easy for the defense to just take up the rest of the day. You know? Tamer Nagel. Oh, you've missed so much today. Where can we begin? I don't know. We might have to do an emergency episode later tonight. Oh shit. I've gone back. I hate it when that happens.
Evidence.
We agree, Your Honor, there's no evidence of it.
It will be omitted. Count.
Anyone know if Georgia is single, asking for a friend? Listen, man. Georgia Kappelman is married to the luckiest man on earth. That's, it's like, I just hope he knows.
3, solicitation to commit murder. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, Donna Adelson solicited Charles Adelson, Catherine McBanois, and or other persons to commit first-degree murder. As to this, are the parties asking this to read with the same or that it does for conspiracy to commit?
Yes, sir.
Yes, Your Honor.
Very well. Element 1, Donna Adelson solicited Charles Adelson or Catherine McBanois or other persons to commit first-degree murder during the solicitation, and which are being requested by the state.
All 4, Your Honor.
Never Trump -Z2Y says, I'm curious as to what Dan's sons have been told. Do they know Uncle Charlie was tried and convicted and sits in prison for orchestrating the ambush and murder of their dad? I'm going to offer an opinion here. And, we got a real nice video coming out soon. When? I don't know. Momentarily. But and I don't often do this, but I'm gonna do it on this occasion. In my opinion, my belief is that those privileged teenage boys don't give a fuck about any of this. Do they even remember their father? Their real father? They were 3 and 4 years old. Do I have memories from 3 or 4 years old? Maybe I have one. Not much. You know, I don't think they give a fuck about any of this. You know what they're doing right now? They're being teenage boys. You know, they're worried about cars and skirt and whatever. I mean, you know, I really don't think that this is a big impact for them. Even, yeah, I believe that they know that their uncle was tried and convicted, and the grandmother's on trial for this. But as far as how it's being sold to them, you have to remember that they have spent what I would classify as their entire life being raised by these people, these bad people. You know? I don't think they care. I don't think they've got that. They've been groomed, brainwashed. And now, you know, they're focusing on there's this air around this case where, oh, those poor boys and blah, 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 blah. I don't think that's a factor at all. I don't think they're sitting there going, oh, my mother murdered my dad. They don't even really remember him. It's a very sad thing. Very sad thing because of what we know. But that's different to what they know. Right? They're chasing pussy, they're driving cars, and they're, you know, doing all that. I mean, that's it. And I'm sure some people are going to be offended by my opinion, but that is my opinion. You know? And I got something to back it up, which we'll be showing you soon. Subscribe to the channel. Yeah. What was the question again? I'm curious as to what Dan's sons have been told. Do they know Uncle Charlie was tried and convicted and sits in prison for orchestrating the ambush and murder of their dad? I would say yes. I would say that doesn't really affect their lives. They've been raised to be selfish. They've been raised to be Adelsons. Groomed all along the way. And that's the saddest thing about this whole thing. You know? And if they are ever to achieve some perspective on what that really means, I don't think it's going to happen when they're 16 and 14. Tamer Nagel got fired today. Glad Metrix is on. That makes me feel better. You're the best, Metrix. Well, thank you, Tamer Nagel. Yeah, I mean, you got fired today for what? You know, get your passport. Come over. Help us with the project.
During the solicitation, Donna Adelson commanded, encouraged, hired, or requested.
Yeah, anybody that thinks that Tamer Nagel getting fired is a clear sign that she needs to just say fuck off and fly over to Portugal and help with the Metrix endeavor. Put well, put love hearts or thumbs up in the comments.
Charles Adelson or Catherine McBanawa or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. The definition of solicit must be given as well. The affirmative defense will be omitted based on lack of evidence.
Your Honor, I believe we're also entitled to a principal instruction on solicitation.
I like your draw to the art of war, Sun Tzu's classic. Metrix, you just answered the riddle. Defense stalls Donna's testimony to throw Georgia off her game and not give her the night to prepare cross. Essentially the art of war. If your opponent gives you an opening, be as swift as a hare. Yeah, I'm not sure that it was as calculated as that. This is just a fudge fuck of this whole trial, well, this whole defense at least has been just one big fudge fuck.
I think the only area,
Go ahead.
I think the only area principle doesn't apply is for conspiracy.
Do you wish for me to move then the two principal instructions to the very end, and then they can be argued as to counts 1 and 3 is necessary?
You could put it there, or you could simply state the principal instruction applies to solicitation, commit murder, as they were previously defined. Or do we need to?
The vote?
We would object, Your Honor. How can one be a principal to solicitation? I'm not sure that that's correct. And as with the previous issue, I want an opportunity to look at that.
Okay, let's think about that question. How can one be a principal to solicitation? That is quite interesting and multidimensional. So the act of solicitation is to solicit somebody to do the murder, i.e., give them information about who it is, pay them, agree with them, do a business deal, essentially. That's the act of solicitation. I think that's the most interesting thing I've heard from Zellman all trial. How can someone be a principal to solicitation? So let's look at the word principal. If you're a principal to murder, that is essentially extending your action to the actual event of the murder. If I solicit you to kill someone else, I'm guilty of the murder that you committed. I'm guilty of that as a principal. So how can I be a principal to solicitation? So if I think he might have a point. That is interesting. How can you be guilty as a principal to solicitation of a murder? Let's see what he says.
Not been requested in previous co-defendants trials, or at least it hasn't been given.
I think the easiest way to settle this would be to move the two instructions to the end of the counts, and then that way they can be argued as necessary for which counts they apply to.
the concern that the defense has, Your Honor, is whether or not it's legally appropriate. That's what I'd like the opportunity to address.
As far as that, you can research the matter, whether it can be argued that someone is a principal and solicitor.
Thank you.
For now, I will just move the two instructions to the end of the counts.
And there in the counts, it just needs to be clearly stated that conspiracy, it does not apply to the conspiracy count. I think we're all in agreement on.
I can add it, but ultimately no instruction can be argued as to defense that it does not apply to. Does the defense wish for me to add at the end of the principal instructions that this does not apply to conspiracy?
Yes, Your Honor, and that might be a moot point depending on the research that I do later.
And I will just add at the bottom the principal theory. Actually, this instruction does not apply to count 2. And I will do that.
My boss is a bitch who's had it out for me for years. She said I left my computer unlocked and I didn't. Oh, the old boss. You left your computer unlocked. Clean out your locker. You're done. My God. My God. Well, I don't think you liked your job anyway, so, you know, do something you're passionate about. You know, it could be the best thing that ever happened to you. Make it the best thing that ever happened to you. You can choose to do that.
For both principal instructions. Moving on to intent as a standalone instruction. This is not a standard instruction, but comes from standard jury instruction 13.1 burglary, which gives a definition of intent. This was given in the prior trial for Charles Adelson, and I have given it previously in murder cases. Is either party requesting it, or do you wish for it to be removed?
We're requesting it, Your Honor.
George's glasses. Best glasses ever.
Intent instruction then will remain.
We would object, Your Honor.
What is the basis?
Okay, what went through Mr. Miyagi's mind this morning when he decided to wear a Hawaiian shirt to court? Why? Why would you do that? Why would anybody do that?
Intent instruction then will remain.
We would object, Your Honor.
What is the basis?
The basis is it's not a standard instruction.
100% speaks to the facts and evidence in this case as to how the jury must determine whether your client had intent. Over objection, it will be given. 3.7, plea of not guilty, reasonable doubt, and burden of proof. All standard language from the current instruction. Does either party wish to be heard?
No, sir.
No, Your Honor.
3.9, weighing the evidence. The opening paragraph will be given. As to the witness testimony, 1 through 5 will be given. As to the give as applicables, which are being requested.
I'm sorry to say it, but, like, someone needs to. There's this, like I just said, there's this whole conception that these boys are being, that have been held captive, and that they're in some angst, and like, oh my God, my mom killed my dad, and like, they're just a couple of spoiled kids. And now they've done the whole puberty thing. Do you remember what that was like? I mean, they're just a couple of spoiled kids. And that's the saddest thing. And it's evident. It's evident in, and I'm not advocating the path of religion for being the only way to bring someone to completion within themselves as a well-rounded person. There's many ways to do that. It doesn't have to be through Christ or Abraham or Buddha or whatever, any of them, or Muhammad or whatever. I'm not advocating that, but I do believe that Professor Markel showed an interest in practicing kosher and synagogue with the boys to make them good people in the world. And that was taken away, despite the bar mitzvah and blah, 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 blah. That's just showboating. As far as Wendy's concerned, that's just showboating. So now, one of the saddest things about this case is that all of those good, healthy qualities that observance of religion can provide, sometimes it goes a little too far, but, it's certainly the basis, as it has been for centuries and millennia, to help people that are born into this world be fair and just and kind and helpful. That was Professor Markel's interest in involving the boys in the observance of kosher, in the attendance at synagogue, and so on. All of that was taken away. And they were dragged, unbeknownst to them, into a world where they would be influenced by excess, by privilege, by desire, which are very common things that are, the antithesis of the teachings that, religion can bring you. And the result is, most likely, that they are ill-adjusted, spoilt, focus on themselves, adolescent children. And that creates the perfect kind of platform, if you like, for them to really not give a fuck about any of this. They want to chase pussy, they want to drive cars. That's it. That really is it.
It's probably number 10 is on one or not, but it's a 6, 7, 8, and 9.
Does the defense have any argument for the giving of number 10?
No, Your Honor, we agree.
Number 6, has the witness been offered or received any money, preferential treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court? Number 9, has the witness been convicted of a felony? Or a misdemeanor involving dishonesty? Whether the state has met its burden of proof, that will remain to the next set of give as applicables. Law enforcement witness, is this requested?
Yes, Your Honor.
No objection.
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration. Expert witnesses. Experts are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert.
The odds of Donna being sent to Katie's cell block are 0. You know, there's only 5 women's prisons or prison facilities in Florida. The main one, the biggest one, is Lowell, which houses Catherine McBanower. But, you know, just because they're in the same prison, you know, that it's all segregated sections. There's no way in hell they're going to put Donna Adelson in the same cell block as Katie McBanower. That's not going to happen. She probably will go to Lowell unless they want to send her to another state like they did with Charlie. But yeah, there's no way in hell that she's going to be housed with Katie McBanower if and when she goes to jail.
Other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As to the issue that came up earlier with the testimony of Linda Bailey, is the state requesting any instruction to be given to the jury concerning that testimony?
Yes, Your Honor.
What is the requested instruction?
I have it typed out for you, would you like to?
Yes.
Copy to the defense. Sorry about the typo in the title. And the certificate of service. It's all on Mr. Evans.
Right, as to the requested instruction, was the witness present in the courtroom during the testimony of another witness or other witnesses? Did the witness violate the court's order not to be present in the courtroom during the testimony of another witness or witnesses? What is the defense's position?
Just one. I have an objection to the first one, but the second one we do.
Was the objection is the second?
Your Honor, it's based, the witness's presence in the courtroom was based on our apparent misunderstanding of the discussion that we had at sidebar last week. As a result, we think that the first one is an accurate statement of the law, but under the facts, the second one would be inappropriate.
Mr. Kappelman, what is your argument for the giving of the second?
I'm fine with just the first one, Judge.
Well, after the expert witness instruction, the next instruction will be, was the witness present in the courtroom during the testimony of another witness or witnesses? Accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case. I believe we have number 3 of the bracketed portions. Are any others being sought?
Your Honor, it has just dawned on me where you're sticking the previous requested instruction about the witness was present in the courtroom during the testimony of another.
Yes.
That's probably better under weighing the evidence as opposed to, because
You're asking for this then to be inserted into the 10, or what would be the 9 questions and make it 10?
yes, because I don't know how much sense it would make if we read, like other witnesses, you may believe, disbelieve all or any expert testimony, and then was the witness present in the courtroom during the testimony of another witness or witnesses. Certainly it's hanging out there as to what does that mean?
I understand what you're getting at. Does the defense wish to be heard as to the position?
We don't have a legal objection, Your Honor.
Then it will be question 10. Let me move that now. All right. Going back to accomplices and informants, for example, a witness who hopes to gain more favorable treatment in his or her own case. Are there any arguments for claims to have helped the defendant has been promised immunity?
Not from the defense, Your Honor.
Those will be admitted. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider, and I believe this would just be her testimony.
Yes, sir.
Your Honor, can we go back to the first bracketed language, please?
Which is being requested?
Claims to have helped the defendant commit a crime. I think that would apply to Ms. McManila and to Mr. Rivera.
State.
So, it's fine, Your Honor. So we're, for the record, as I understand it, the bracketed languages under accomplices and informants,
who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment.
All right, yes, sir.
So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. There have been no children witnesses. The defendant has not testified. Witness talk to lawyer. Is either party requesting this?
Yes, Your Honor.
That will be given. And be given all cases, you may rely upon your own conclusion about the credibility of any witness. That will be given. Defendant not testifying. This will be given in full. And we'll just change the pronouns to all feminine. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. As to defendant's statements, I do not believe there was ever a statement given by the defendant to law enforcement. This specifically goes to whether the statement was freely and voluntarily made. As to that, as there is no law enforcement statement, this will be removed. Does any party wish to be heard concerning this?
No, sir.
No, Your Honor.
Rules for deliberation. Standard instruction, this will be given. Does either party wish to be heard?
No, sir.
No, Your Honor.
Cautionary instruction, does either party wish to be heard?
No, sir.
No, Your Honor.
Single defendant, multiple counts, does either party wish to be heard?
No, sir.
No objection.
3.12 verdict. Any objection or request?
No.
Moving on to the verdict form. Count 1, we the jury finds as follows. As to count 1 of the indictment, first-degree murder. Check only one letter choice as to this count. Option A, defendant is guilty of first-degree murder. Option B, defendant is guilty of the lesser included offense of second-degree murder. Option C, the defendant is guilty of the lesser included offense of manslaughter. Option D, the defendant is not guilty as to count 1. Any objection or request?
I'll make the same request that I make in all cases. We would request that not guilty be the first option, since she has the presumption of innocence. We would also request that the words guilty and not guilty not be in all caps and bold.
As to replacing the order, I believe the standard instruction not only identifies guilty, not guilty, but the state is the plaintiff in this matter and has brought the action. They are entitled to the first option. That is overruled. As to the options being in bold or not, does the state have a position at which is to raise?
The only thing I would...
We don't want you to use bold typeface when you say guilty or not guilty. Really? Yeah. Because that's what fucking a jury decides it on. Oh, well, it was bold, so we better be bold and vote guilty. Unbelievable, the things that they argue, this defense team. Or, Zellman in particular, are crazy to me. Just like, what? We would ask that guilty not be in bold.
Just we leave them in...
Hey, Zellman, what about all this other stuff that we call evidence? That's what you should be worrying about, not the fucking typeface, my friend.
That makes it clear for the jury to differentiate between each of the counts, but I don't have any real strong feelings, but I see why they would be involved.
So you are requesting for it to remain the same or to not be voted?
I request they remain the same simply because I think it makes it much clearer to the jury to identify what is what. It's not suggesting anything, it's just making sure they recognize which box they're checking.
Very well. It will remain in bold. This is for the purpose of clarity. No other purpose is involved. As to count 2, we, the jury, finds as follows: as to count 2 of the indictment, conspiracy to commit murder. Check, only one letter choice as to this count.
Your Honor, what about all caps for the guilty, not guilty words in count 1?
This is stylistic because ultimately this has no bearing on how they're evaluating the evidence, correct?
I think the same reason why I'm asking for the names of the charges to be in regular caps, not all caps, throughout the instructions. It's the same principle.
State, do you have a position?
Your Honor, I think it's, to me, when it comes time to sign the verdict, we want it real clear which boxes they are checking. I think this makes it the most clear. That's the reason I think the all caps and the bold are appropriate. The only stylistic change I would suggest, and like count 1, probably need to move the degree murder that's up under it over to fully under B, under subsection B, and manslaughter fully under subsection C, so it's not up under the check box. But other than that, I think throughout the verdict form we're going to be asking the same thing. Leave it as is because I think it makes it much clearer to the jury when they're looking at it. You know what you're checking.
As to the body of the instructions, we'll grant the defense's request for the verdict form itself. Again, the object specifically is to have clarity as to what verdict the jury is reaching and why. The form will remain as it's currently presented. 2 options, guilty and not guilty for count 2. Same 2 options for count 3, guilty and not guilty.
Suggest, Your Honor, for count 3 that you move it off page 16 to the top of page 17.
I've been making several edits, so my pages aren't the same, but it will flow to where it's not being broken up between pages. All right, closing argument 2.7. Any objection or request?
No, sir.
No, Your Honor.
How much time is each party anticipating for their closing argument?
2 hours, Your Honor.
We would say the same, Your Honor.
Very well. Both parties will have 2 hours to present their arguments. Ms. Kappelman, yours will be broken up based on what the law permits between your initial closing and any rebuttal that you wish to give to the defense. You'll need to be mindful of the time. I will help you in that regard as well. 2 hours.
Don't help me too much.
Submitting the case to jury, just with the time, nothing else. Any objection or request?
No, sir.
The items that are going to be sent into the jury room, I believe we have photos, discs, jump drives, written reports. Is there anything that the parties are not asking to go back into the jury room?
Just the demonstratives, Judge, on the exhibits, I think.
A demonstrative is not admitted, so yes, I would agree. It is not to go back into the jury room.
Ms. Dugan and I spoke earlier during the trial about going through especially 73 and 73 and make sure it complies with the court's ruling, so we'll do that before they're sent back.
All right, and I will just leave it then. Photographic discs, jump drives. reports, and document exhibits will be sent to the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. And the final instruction, when we reach the end of the case, instruction upon discharge of the jury. Standard language once again. Any objection or request?
No, sir.
No, Your Honor.
I believe the remaining edits that I need to make within the body of the instructions concern the capitalization and the names. I believe the state has requested within 3.5A for manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markell. I believe the defense is reserving any objection as to that instruction. That will remain for now. Also added to both principles, this instruction does not apply to count 2. The defense was asking for time to review that as well. Or was it specifically as to count 3?
It's specific, principle applies to count 1. There's not disputing that in any way, shape, or form. I wanted the opportunity to look at it as to count 3.
As to the language, this instruction does not apply to count 2 appearing in both principal instructions. Does the defense wish to be heard?
No, Your Honor.
All right. Once I've made my edits, I will send through my assistant an updated copy of the instructions. I will also rule on the items that were submitted by the defense prior to the end of its case. And then from there, we will roll into the instructions and the closings tomorrow morning. Please report by 8:30. We will await the jurors. Any issues that can be resolved concerning the exhibits, certainly confer and advise tomorrow. We're in recess.
In recess, there you go. What a day. What a day of mostly nothing. Hello? Oh, there they are. And there she is, thinking, should I try and revoke my wish not to testify in my defense? Or is she going to change her mind? When she sits down at night and they bring her a little something to eat. Spaghetti and potatoes. It's not the best decision-making material, but it is what it is. Constance. Why, of course, need prettier stationery? Appearances count, you know, they do. She doesn't know what the fuck to do, does she? She's been waiting for that for 2 years. She's been trying to plan for meth heads to take her grand piano and come in and say, Katie McBanower told me that it was all her. Katie McBanower told me that she was going to get those Adelsons. Good job, Donna. What do I think? Is she going to change her mind and testify? I guess I don't think so. If you had to me, if you asked me to bet $5 right now, and he said, "Are you going to bet $5 that she's going to change her mind and testify, or stick with her decision and not testify?" I would probably put my $5 on that she won't testify. But I wouldn't want to go much higher than that, which means it's all to play for. Wow, what a day. It's strange. I feel like we've done a lot, and I also feel like we've done nothing. Man. How long have we been on? 8 hours, 42 minutes. Jesus. All right, well. What else can we say right now? I don't know. Just don't know. Not much. But either way, tomorrow we have either got a surprise request from the defense to say, "Hey, Your Honor, you know when I said that I didn't want to testify? Well, I do. So you better let me." And from everything that we've learnt, he would probably allow that as long as it happens before opening statements. So she has managed to buy herself that time. And man, I would not want to be Donna Adelson tonight, trying to weigh all that up. Ultimately, the decision for Donna to send the jury back when they've only got what's been presented so far, they've only got that to work with. If it were me, I would want to testify, even with cross-examination. You gotta take it on. Don't be a pussy. I'm amazed that she's pussying out on this. Is it smarter for her to not testify? Well, maybe if the defense had put on any case at all that addressed the issues of the state's case, but they didn't. They only talked about events that happened post-murder, when the prosecution talked mainly about intent prior to the murder. You know? That's their whole point. And the defense didn't address that at all. So at this stage, I would want to testify if it were me, and maybe she will. Either way, tomorrow we've either got Donna testifying, probably unlikely in my opinion, or closing arguments. And of course the state go first, which is going to be Georgia Kaplan, obviously, and that's going to be brilliant. What a thing to listen to. Don't miss it on Metrix. Keep an eye on Discord, keep an eye on Twitter, keep an eye on those YouTube feeds. Subscribe to the channel, ring the bell, and so on. Support the channel. buymeacoffee.com/True Crime Metrix. PayPal. Why don't we check out PayPal so we can thank all of the thousands of kind supporters that help our cause. One by one, we're going to go through name by name. There's either going to be one or none. So, yeah, but hopefully there will be. You don't? Yeah, there's none. Just Sally this morning. Thank you, Sally, for sending us that $50. That is helpful. That is helpful. Okay, so I'm going to have to go. We got to go. We got to prepare for tomorrow, right? It's going to be a big day. Come back, join us, True Crime Metrix. Many thanks to the chatters, the super chatters, the super sticker givers, the super coffee go-getters, and the bulletproof Metrix moderators. Best moderators in the game. Have a good night, everybody. Adios.